It's voiceover me. So like you guys already know, YouTube deleted my original Requiro account on February 23rd, 2026, and sadly this video, I weirdly don't have it saved on my hard drive or anything like that. I don't know why. I 100% thought I did. I save all my videos, but sadly this video just does not exist anymore, so I do apologize about that so much. I tried every single method, tried to hunt this original video down, but the one thing that still does exist is the full audio version of this video, so that's directly on Spotify, and that's what basically this video is here. So all the accurate information is still here. It's exactly the same. The only difference is there is no visual going on, so this is just basically a podcast. So I do apologize so much about this. I 100% thought I had this saved on my hard drive, but it's not there whatsoever, so sorry about that, guys. So just sit back, relax, enjoy this video, just pop your earplugs in or do some painting or something. But yeah, do apologize, no visual for this, but all the accurate information is still here. It's just welcome to Requiro. Today we are going to be talking about more updates on the Luigi Mangione case. There's been a lot of updates since my last video on Luigi Mangione, and that was about 2 weeks ago. I think it's because Luigi Mangione is going to show up in trial next month in September. I will be covering that, so don't worry. So I think that's why there's been so much coming out lately on Luigi Mangione's case. Like, there was a couple of months ago when I first started this channel, where it was like, there was a new updated video every week for a solid month, then slowly trickling in over the last couple of months. That's what my opinion is anyway. So you can see I'm back home now in front of my bookshelf. I was worried I was have to film this dog sitting again because there was a little bit of an emergency and they needed me, but I'm here. Hopefully I have a couple of hours where I can film this all in one go here. So, and all the information and sources will be on this week's episode on the website, so if you guys want to go check it out, go ahead. And if there's anything I got wrong, please let me know in the comments down below. I'll bring it up in my next video, or I'll pin it in the comments down below, because I am one person doing all this. No one else is here. Now, let's get into the video. Yes, I will be covering the document I wasn't able to cover in my last Luigi Mangione video. Like, literally when I uploaded that video, a document came out and it was kind of big, and I literally saw it. I made a reel or a short. I posted it on my social medias. I don't think I posted here, but I did see it, so I am going to be covering that as well here as well. This is the most current information we have on Luigi Mangione's case as me filming this video. So today is August 15th, 2025. Man, I'm sleepy. The 25th of July, 2025. So these are two documents from Luigi Mangione's legal team in New York. So both of these came out on the same day. Basically, this document is from Luigi Mangione's legal team, basically asking the prosecutors to actually show actual proof, to have the death penalty put on Luigi Mangione, like show the actual proof they have against him, to have that charge put on Luigi Mangione, because for a while now, and if you've watched my other videos, you've probably seen and noticed the death penalty was very much up in the air for such a long time and wasn't really finalized, but it was still very much there. So basically, Luigi Mangione's legal team is asking to actually have things finalized and show the actual proof, to have the death penalty put on Luigi Mangione. And like we've seen before, it's very much like all talk and no show from the prosecutors, but I will talk about that in more detail once I show you guys the document. So I'll put it up on screen for you guys.
United States District Court, Southern District of New York, United States of America, against Luigi Nicholas Mangione, defendant. Notice of motion. Please take notice that upon the annexed memorandum of law, the undersigned will move the court, on a date convenient to the court, for an order directing the government to provide an informational outline concerning certain of the purported aggravating factors set forth in the Notice of Intent to Seek the Death Penalty, ECF Doc. Number 25 herein, dated July 25, 2025, New York, New York. Moskowitz, Colson, Ginsberg and Schulman, LLP. Avram C. Moskowitz, Elon Schulman, Christopher R. F. Agnifilo, Intrator LLP, Karen Friedman Agnifilo, Mark Agnifilo, Jacob Kaplan, attorneys for Luigi Mangione. 2. Clerk of Court, by ECF or Counsel of Record, by ECF. United States District Court, Southern District of New York, ex-United States against 25 CR 176. MMG, Luigi Mangione, ex-motion for informational outline of certain aggravating factors I introduction defendant, Luigi Mangione, through undersigned counsel, and pursuant to the 5th, 6th and 8th Amendments to the Constitution of the United States and the Federal Death Penalty Act, FDPA, hereby moves the court to direct the government to provide him with an informational outline concerning the statutory and non-statutory aggravating factors that it intends to prove at a capital sentencing phase of his trial to support a death sentence. At such a sentencing phase, aggravating factors will play a role similar to offense elements at a guilt-innocence trial, but here, for most of the aggravators, including the critical ones involving the alleged creation of a grave risk of death to one or more persons other than the victim, the crime's effects on the deceased's family, friends and co-workers, and the alleged future dangerousness of Mr. Mangione, the indictment and the government's death penalty notice contain only bare bones, vague allegations, lacking any information about the facts upon which the government intends to rely. This paucity of detail prevents Mr. Mangione from preparing to defend against these aggravating factors at a sentencing phase. It also prevents the court from carrying out its critical pre-trial duty to act as a gatekeeper against invalid factors and inadmissible evidence, as most other district courts, including several in this circuit, have recognized an appropriate way to avoid these problems is for the government to provide an informational outline of the essential facts underlying its alleged aggravating factors. Such an outline functions much like a bill of particulars does for a guilt-innocence trial when the indictment is similarly conclusory. An informational outline should be provided within 90 days, no later than October 24, 2025. By that date, the government will have had more than 10 months to investigate and prepare its case, and surely will be able to share with the court and the defense the essential facts underlying its aggravating factors, and there is clear precedent from other district courts for such a deadline. See, for example, United States v. Gendron, number 22 CR 109 LJV, 2024 WL 3,647,779, at star 6, WDNY August 2nd, 2024, requiring production of informational outline by September 3rd, 2024, 1 month after entry of order. Moreover, since the court has expressed its intention to try this case in 2026, any further delay in providing the informational outline would interfere with the defense's ability to complete the time-consuming process of investigating and preparing to confront and rebut those factual allegations. The need for sufficient time to conduct such an investigation is particularly acute in this case because the government announced its intention to seek the death penalty even before the defense had an opportunity to conduct a mitigation investigation and make a detailed factual mitigation presentation to the Department of Justice. 2. Factual background. If this case reaches a capital sentencing phase, the government will seek to persuade the jury that Luigi Mangione should be executed for shooting and killing Brian Thompson, the chief executive officer of United Healthcare, in the vicinity of West 54th Street and 6th Avenue in Manhattan, on December 4, 2024. Mr. Mangione was arrested by the police in Altoona, Pennsylvania on December 9, 2025, and was indicted by a grand jury in New York County on December 17, 2024 on 11 charges, including first and second-degree murder. On December 19, 2024, following his waiver of extradition and return to New York, Mr. Mangione was arrested by federal authorities and presented before a magistrate judge in this district on a criminal complaint charging him, inter alia, with 2 counts of interstate stalking and 1 count of murder through the use of a firearm, in violation of 18 U.S.C. Nino 24, J. On April 1st, 2025, Attorney General Pam Bondi directed the U.S. Attorney for the Southern District of New York to seek the death penalty against Mr. Mangione. A capital indictment was returned against Mr. Mangione on April 17, 2025. The government filed its notice of intent to seek the death penalty on April 24, 2025, alleging two statutory aggravating factors, that is, substantial planning and premeditation and grave risk of death to additional persons, and three non-statutory aggravating factors, that is, victim impact, selection of site for an act of violence and future dangerousness. Both the indictment and the notice of intent are bare-boned and do not provide details regarding the facts the government intends to prove at a penalty phase with respect to the charged aggravating factors. The allegations in the notice of intent filed in this case are generalized and unbounded, leaving the defense blind as to what acts, events, harms, in short, what facts, the government intends to prove. The most glaring examples are the aggravators likely to spawn the most extensive litigation over their validity, scope, and admissibility, and to consume much of the government's sentencing presentation if permitted. The statutory aggravating factor of grave risk of death to additional persons and the non-statutory factors of victim impact and future dangerousness. For the first of those factors, the grave risk of death to additional persons, the notice does not identify what other people were put in grave risk of death, nor does it provide any details as to what conduct by the defendant allegedly placed such individuals at a grave risk of death. The notice is equally silent with respect to the facts the government intends to prove regarding the impact that Mr. Thompson's death has had on his family, friends and co-workers, saying only that the government will prove the victim's personal characteristics and the impact of the victim's death upon his family, friends and co-workers. The notice does not specify what personal characteristics the government intends to prove, which family members, friends and co-workers were impacted by his death, or how they were impacted. Finally, with respect to the non-statutory aggravating factor of future dangerousness, the notice simply alleges that Mr. Mangione expressed intent to target an entire industry and rally political and social opposition to that industry by engaging in an act of lethal violence. It further alleges that he sought to evade capture by law enforcement and travelled across state lines with a privately manufactured gun and silencer. The notice does not provide any detail as to when and how he expressed an intent to target an entire industry, or in what way he intended to target the industry, other than by rallying political and social opposition to that industry, or how any potential political and social opposition to the industry posed a risk of future dangerousness. The notice certainly does not contain any factual statement as to how the government intends to prove that Mr. Mangione is a future danger to anyone. At the initial arraignment and pre-trial conference held on April 25, 2025, the court stated that it intends to set a firm trial date in 2026 at the next scheduled conference, on December 5, 2025, TRP 17. A 2026 trial date would require that this case move exceptionally quickly, especially considering that capital cases, on average, do not proceed to trial until at least 42 months after indictment. One argument: Luigi Mangione is entitled to meaningful advance notice of the theories and facts the government intends to prove at a capital sentencing phase to establish its aggravating factors. The sentencing phase of a capital trial parallels an ordinary criminal trial in certain respects, with aggravating factors functioning much like elements of the offence. The government must prove each aggravating factor beyond a reasonable doubt. Jurors may not consider an aggravating factor unless they unanimously find it so proved, and their ultimate verdict turns on their findings of such factors, along with the defendant's mitigating factors, which are analogous to affirmative defenses. See 18 U.S.C. Section 3593, C.E., United States v. Fell, 360 F, 3D 135, 142, 2DC 2004. Like every defendant, Luigi Mangione is entitled to meaningful notice of what the government intends to prove, so that he can prepare and present a defense, including any legal or evidentiary challenges. Thus, in an ordinary criminal prosecution, a bill of particulars is required when the indictment charges are phrased in general terms so that they do not advise the defendant of the specific acts the government will seek to prove. United States v. Chen, 378 F, 3D 151, 162-63, 2DC 2004, C Fed, Akrim, P7, C. 1. Indictment must include a definite written statement of the essential facts constituting the offence charged, Fed, Akrim, P7, F. Authorizing court to direct the government to file a bill of particulars to supplement the indictment, as justice requires. See also United States v. Davidoff, 845 F. 2D 1151, 1154, 2D SIN 1988. Purpose of Bill of Particulars is to prevent surprise. A Bill of Particulars is particularly appropriate when the 1C Declaration of Matthew Rubenstein, Capital Resource Counsel and member of the Federal Capital Trial Project, dated July 22, 2025, attached as Exhibit A hereto. Potential acts covered by the charges are broad in scope or wide-ranging. United States v. Bortnovsky, 820 F. 2D 572, 574-75, 2D SIN 1987, United States v. Clarkson Auto Ellick, Incorporated, 2014 WL 3,906,324, at star 34, WDNY August 8, 2014, at a capital sentencing phase, with Mr. Mangone's life at stake. The right to meaningful notice of the government's aggravating factors enjoys heightened due process protection. See Langford v. Idaho, 500 U.S. 110, 123-25, 1991. Gardner v. Florida, 430 U.S. 349, 358-59, 1977. The FDPA permits the jury to consider only aggravating factors for which notice has been given by the government. 18 U.S.C. Section 3592. C. While the statute does not specify the kind or extent of the notice required, as another district court in this circuit recognized, at a minimum, due process requires a defendant to receive sufficient notice of aggravating factors to enable him to respond and prepare his case in rebuttal. United States v. Wilson, 493 F. Sub 2D 364, 377, EDNY 2006, United States v. Duncan, 2008 WL 656,036, at star 5, D. Idaho March 6, 2008, same, United States v. Kaczynski, 1997 WL 34,626,785, at star 18, ED Cal, November 7, 1997, same. Otherwise, it raises the specter of unfair surprise and potentially prejudices defendants' ability to defend against the government's efforts to impose the death penalty. United States v. Rodriguez, 380 F. Sub 2D 1041, 1057, DND 2005. In any capital case, the government must give the defendant notice of all aggravating factors sufficient to enable the defendant to respond and prepare his case for sentencing. United States v. Gendron, 2024 WL 3,647,779, at star 2. That means, at minimum, the government must inform the defendant of the theories and facts that the government will use to establish each aggravating factor in the case. Quoting United States v. Lera Plaza, 179 F. Sub 2D 464, 472, EDPA 2001. See also United States v. Burkhalter, 2021 WL 3,519,281, at star 910, WDMO, August 10, 2021, same, United States v. Lujan, 2008 WL 11,359,151, at star 2324, DNM June 26, 2008, same, Duncan, 2008 WL 656,036, at star 5, same, United States v. Diaz, 2007 WL 196,752, at star 23, ND Cal, January 23, 2007, same. Requiring the government to disclose such theories and facts also enables this court to carry out its essential gatekeeping function at a capital sentencing phase. United States versus Gendron, 2024 WL 3,647,779, at star 2. An informational outline also assists the court in fulfilling its role as an evidentiary gatekeeper. See 18 U.S.C. 3593. C. The screening of aggravating factors is essential in channeling, directing, and limiting the sentence's discretion to prevent arbitrary and capricious imposition of the death penalty. ID. Cleaned up. By mandating advance notice, the court can ensure that it has the information necessary to consider the critical, complex defense motions that will follow, and make reasoned, deliberate choices in conducting its constitutionally mandated screening of aggravating factors, in order to prevent arbitrary and capricious imposition of the death penalty. United States versus Hammer, 2011 WL 6,020,157, at star 3, MDPA, December 1, 2011. See also, for example, United States versus Basciano, 763 F sub 2D 303, 357 N, 40, EDNY 2011, United States versus Kerag, 370 F sub 2D 275, 280 81, DDC 2005, requiring government to notice further specifics for aggravating factors also provide S. the court with some frame of reference for ruling on objections to the death penalty notice. In the absence of an informational outline, Mr. Mangione will not be in a position to present those challenges because his only notice of the aggravators will be the bare-bones allegations in the government's death penalty notice. Even comprehensive discovery about aggravating factors cannot substitute for such notice of the government's anticipated presentation, especially where, as here, the discovery is voluminous. As one court has explained, the fact that the precise acts and/or events may have been disclosed in the course of discovery does not obviate the need for a more specific notice. Even if the government has provided defendant with documents detailing specific acts, the government has not yet indicated which acts and/or events it intends to use at sentencing. In fact, the characterization of the discovery provided as extensive lends further support for requiring the government to identify the particular acts upon which it will rely. Extensive discovery could make it difficult for defendant to ascertain which precise discovery will be used against him. Rodriguez, 380 F sub 2D at 1057, 58, C. Kaczynski, 1997 WL 34,626,785, at star 19, same, Diaz, 2007 WL 4,169,973, at star 5, merely referring to a range of several hundred pages, or thousands in some cases. In discovery is not an informative outline. Much is left to guesswork. Notice means notice. It does not mean a scavenger hunt for clues in discovery, including in redacted pages. As in other cases, the government should be directed to provide an informational outline of its aggravating factors, particularly its sketchy allegations for grave risk of death to additional persons, victim impact and future dangerousness based on these due process considerations, the FDPA's notice requirement, and inherent judicial authority. Most district courts have agreed to order the government to produce, in advance, an informational outline of what specifically it intends to prove at a capital sentencing hearing, for at least certain aggravating factors. That appears to include every district court in this circuit to address the issue. See, for example, United States versus Gendron, 2024 WL 3,647,779, WDNY August 2, 2024, United States versus Sapov, number 117 CR 722, ECF number 482, SDNY August 11, 2022, Basciano, 763 F sub 2D at 357, United States versus Jacques, 2011 WL 1,675,417, at star 1, 29, DVT, May 4, 2011, overruled in part on other grounds, 684 F, 3D 324, 2DC 2012, Wilson, 493 F sub 2D 364, 377-78, United States v. Bin Laden, 126 F sub 2D 290, 304, SDNY 2001, United States v. Walker, 910 F sub 837, 855-856, NDNY 1995. It also includes numerous district courts in other circuits across the country. 2C, for example, Burkhalter, 2021 WL 3,519,281, at star 9, United States vs. Lujan, 530 F sub 2D 1224, pages 1269-70, DNM 2008, Rodriguez, 380 F sub 2D at 1057 and 1058, Kerek, 370 F sub 2D at 280-81, Lera Plaza, 179 F sub 2D at 472, United States vs. Glover, 43 F sub 2D 1217, 1222, D. Kansas 1999, United States vs. Savage, 2013 WL 1,934,531, at star 11, 21, EDPA, May 10, 2013, Hammer, 2011 WL 6,020,157, at star 24, Duncan, 2008 WL 656,036, at star 5, United States v. O'Reilly, 2007 WL 4,591,856, at star 5, E.D. Mitch, December 28, 2007, Diaz, 2007 WL 4,169,973, at star 3, United States vs. Gooch, 2006 WL 3,780,781, at star 23, DDC December 20th, 2006, Kaczynski, 1997 WL 34,626,785, at star 19. As discussed in greater detail below, at least 3 of the 5 aggravating factors in the government's death penalty notice, grave risk of death to additional persons, victim impact and future dangerousness, require an informational outline in order to provide a defense with adequate notice of the theories and facts the government intends to prove. 1. Grave risk of death to additional persons. The government's death penalty notice alleges that in the commission of the offence Luigi Mangione knowingly created a grave risk of death to one or more persons in addition to the victim of the offence, ECF number 25 at 2. This simply repeats the language of the aggravating factor listed in the FDPA 18 U.S.C. section 3592, c. 5. It provides no notice of which persons are covered, nor does the aggravating factor, as alleged, identify which act or acts by Mr. Mangione knowingly created a grave risk to such individuals. Indeed, given that the shooting of Mr. Thompson was done at close to, some courts outside this circuit have held that a defendant is not entitled to advance notice of the specific evidence to be used to establish the government's aggravating facts and theories. See, for example, United States vs. Requiro, 441 F. 3D 914, 929-930, 11th to 2006, United States vs. Higgs, 353 F. 3D 281, 325, 4th to 2003, United States vs. Lee, 274 F. 3D 485, 495, 8th to 2001. The Second Circuit has not addressed that issue. Range and early in the morning, when the street was nearly empty, it is hard to imagine, without further specificity, how the government intends to prove this aggravating factor. Accordingly, the court should follow the lead of other district courts and order the government's informational outline to include more specific notice for this aggravating factor. See, for example, United States vs. Gendron, 2024 WL 3,647,779, at star 4, ordering the government to provide an informational outline detailing 1. The identity of the people towards whom defendant allegedly knowingly created a grave risk of death, and 2. The acts through which defendant knowingly created that grave risk of death, Lira Plaza, 179 F sub 2D at 473, ordering production of informative outline where neither the indictment nor the NOIs specify which additional persons the defendants are alleged to have put at risk during their alleged crimes. Savage, 2013 WL 1,934,531, at star 12. Nowhere in the revised notice of intent or in the indictment does the government allege any individuals, other than the victims, who were exposed to grave risk during the commission of the charged murders. The government shall submit an outline of the evidence it intends to use at the sentencing phase with respect to this aggravating factor. Diaz, 2007 WL 196,752, at star 4, ordering informative outline because He government did not explain in its briefs or at oral argument who was put at grave risk, what the grave risk was, or how the defendant knowingly created the risk. 2. Substantial planning and premeditation. The government's death penalty notice alleges that Luigi Mangione committed the offence after substantial planning and premeditation to cause the death of a person. ECF number 25 at page 2. Again, this simply repeats the language of the aggravating factor listed in the FDPA 18 U.S.C. section 3592, c. 9. The notice is devoid of any of the facts the government intends to prove to establish such planning and premeditation, including, most importantly, what acts by Mr. Mangione constituted the planning, when and where those acts occurred, and which person's death was planned and premeditated. Again, in similar circumstances, other courts have ordered the government to furnish an informational outline setting forth at least the factual basis for this aggravator. See, for example, United States v. Gendron, 2024 WL 3,647,779, at star 4, requiring government to identify the factual basis for this factor, including which acts constituted planning and where and when those acts took place. United States v. Schlesinger, 2021 WL 5,578,901, at star 3, Diaz, November 30th, 2021, requiring disclosure of specific acts. United States v. Con Ui, 2016 WL 9,331,115, at star 18, MDPA, January 28, 2016, requiring disclosure of witnesses and evidence. United States v. Cyansha, 2015 WL 13,798,674, at star 4, CD Cal, September 4, 2015, factual basis, Hammer, 2007 WL 6,020,157, at star 3, requiring disclosure of information government plans to present. Diaz, 2007 WL 196,752, at star 4, requiring disclosure of factual basis. Glover, 43 F sub 2D at 1221-22, directing factual amplification by government. 3. Victim impact. In its death penalty notice, the government alleges a broad-ranging non-statutory aggravating factor, victim impact, involving the life of the victim and the crime's effects on his family, friends and co-workers. For this, the notice says only that the government will prove the injury, harm, and loss caused by Luigi Mangione to the family, friends and company, workers of Brian Thompson, as evidenced by the victim's personal characteristics and by the impact of the victim's death upon his family, friends and co-workers. ECF number 25 at 3. The notice is silent on what characteristics of Mr. Thompson the government intends to prove, which family members, friends and co-workers were impacted by his loss, and the nature of the impact suffered by each relative, friend or co-worker the government intends to rely on. Other district courts, including in this circuit, have recognized that the range of human suffering, whether physical, emotional, or economic, is vast. Goes without saying. Bin Laden, 126 F sub 2D at 304, C. Wilson, 493 F sub 2D at 378. The category of victim impact is vast. Green, 2008 WL 4,870, at star 21, same. Thus, an oblique reference to victim's injury, harm, and loss, without more, does nothing to guide the defendant's vital task of preparing for the penalty phase of trial. Bin Laden, 126 F sub 2D at 304. It also hamstrings this court's performance of its gatekeeping role in this especially fraught and sensitive area of the case. As the district judge who handled the first mass killing case tried under the FDPA observed, this is the most problematical of all of the aggravating factors and may present the greatest difficulty in determining the nature and scope of the information to be considered. United States v. McVeigh, 944 F sup 1478, 1491, Decolo 1996. Full stop. The propriety of providing a defendant with such information is further underscored by the particular danger of eliciting an emotional reaction inherent in victim impact evidence. United States v. Casey, 2013 WL 12,190,487, at star 2, DPR March 1, 2013, O'Driscoll, 203 F sub 2D at 340, MDPA 2002. The presentation of victim impact evidence can be problematic because of the potential for emotional outbursts during the testimony. Point 3. Limitations on such testimony obviously need to be hammered out well in advance of trial by the parties and the court, rather than on the fly as witnesses are about to be sworn in, or, worse, while they're on the stand. See, for example, United States v. Johnson, 713 F sub 2D 595, 625, ED La 2010. During sidebar discussion of defense objection, victim's overwrought wife remained on stand. 3. Victim impact testimony has unsurpassed emotional power on a jury. United States v. Johnson, 362 F sub 2D 1043, 1107, ND Iowa 2005. The federal judge in that case described it as the most forceful, emotionally powerful, and emotionally draining evidence that he has heard in any kind of proceeding in any case, civil or criminal, in his entire career as a practicing trial attorney and federal judge spanning nearly 30 years. ID. And continue, D, to cry within feet of jurors, leaving them totally vested in her plight and feel, her misery unattended by counsel and the court. Thus, faced with similarly conclusory notices for victim impact, courts in other cases have ordered the government to more specifically articulate the nature of this aggravator. Glover, 43 F sub 2D at 1225. One court directed the government to specify which members of the victim's family have suffered, the nature of their suffering, and the nature of the permanent harm, for example, whether members of the family sought counseling or other medical treatment, such as hospitalization. ID. Other courts have entered similar orders. See, for example, United States v. Cooper, 91 F sub 2D 90, 111, DDC 2000, T. The government shall amend its notice of intent to include more specific information concerning the extent and scope of the injuries and loss suffered by each victim, his or her family members, and other relevant individuals, and as to each victim's personal characteristics that the government intends to prove. Burkhalter, 2021 WL 3,519,281, at star 9, ordering government to provide an informational outline regarding victim impact evidence, United States versus Plo, 2013 WL 1,673,109, at star 4, DRI April 17, 2013, same, United States versus Talik, 2007 WL 4,570,704, at star 9, NDW VAR, December 26, 2007, same, Lera Plaza, 179 F sub 2D at 475, same, Duncan, 2008 WL 656,036, at star 8, same, Green, 2008 WL 4,870, at star 20, same, O'Reilly, 2007 WL 4,591,856, at star 5, same, United States versus Williams, 2013 WL 1,335,599, at star 40, MDPA, March 29, 2013, same. Most recently, the Gendron Court, finding that an informational outline is necessary to give notice of the extent and scope of the injuries and loss that the government alleges, ordered the government to provide an outline with the personal characteristics it intends to prove as to each victim, the identities of the people whom it intends to prove were affected, and the type and scope of the loss, injury, and harm suffered. United States versus Gendron, 2024 WL 3,647,779, at star 4. Court, like others, should therefore order the government to outline the type and scope of the loss, injury, and harm suffered by each victim, his or her family members, and other individuals as relevant, and the personal characteristics of each victim that it intends to prove. Gooch, 2006 WL 3,780,781, at star 23, c. For example, Schlesinger, 2021 WL 5,578,901, at star 3, requiring government to provide a list of the personal characteristics of the victims that the government intends to prove and particularized categories of injury, harm, and loss. Con UI, 2016 WL 9,331,115, at star 19, ordering informational outline on victim impact aggravator specifying list of personal characteristics of victim, whether any testimony will be introduced from persons not named in the NOI, particularized categories of harm and loss that government intends to present, and any other pertinent information defendant would need to adequately prepare to respond. Savage, 2013 WL 1,934,531, at star 19, ordering government to provide either actual victim impact statements or an outline of the specific evidence about which each victim will testify. Plow, 2013 WL 1,673,109, at star 4, 6, the court hereby orders the government to provide an outline of its victim impact evidence. 4. Future dangerousness, the final non-statutory aggravator crafted by the government for its death penalty notice is future dangerousness. The notice is vague and unspecific about this, saying only that Luigi Mangione presents a future danger because he expressed intent to target an entire industry and rally political and social opposition to that industry by engaging in an act of lethal violence, and he took steps to evade law enforcement, flee New York City immediately after the murder, and cross state lines while armed with a privately manufactured firearm and silencer, ECF number 25-3. The notice does not explain in what way Mr. Mangione intended to target an entire industry. Does the government intend to prove that he intended to kill others in the healthcare industry, or does it intend, as suggested by the phrase, and rally political and social opposition to that industry, that he was hoping to spark a political and social movement to change the healthcare industry? If the government intends to prove that Mr. Mangione intended to kill others in the healthcare industry, who are the intended victims and what proof is there of such intent? If Mr. Mangione only intended to rally political and social opposition to the healthcare industry, in what way does that make him a future danger to anyone? As for the allegations that Mr. Mangione attempted to evade law enforcement and fled New York City carrying a privately manufactured firearm and silencer, what relevance does that have to proving future dangerousness? Does the government contend that any alleged murderer who flees the scene of the crime with the alleged murder weapon presents a future danger that warrants imposition of the death penalty? If not, then what facts make Mr. Mangione's alleged flight unique, such that he presents a future danger so great that he deserves the death penalty? In that regard, it is worth noting that Mr. Mangione was apprehended in a restaurant in Altoona, Pennsylvania without incident, not exactly indicative of someone who presents a future danger to others. Unless the government details the facts that it intends to rely on to prove the future dangerousness aggravator, the defense will be unable to prepare to rebut the government's claim at trial, or even to raise legal arguments before trial against the evidence the government intends to rely on. Because the future dangerousness aggravator is so amorphous, and the type of evidence the government can rely on to attempt to prove it is so broad, numerous courts have required the government to provide an informational outline detailing the evidence it intends to use to prove this aggravating factor. See, for example, U.S. v. Fell, 2017 WL 10,809,983, DVT, January 20th, 2017, United States vs. Con UI, 2016 WL 9,331,115, MDPA, January 28, 2016, United States vs. Schlesinger, 2021 WL 5,578,901, Dieras, November 30, 2021. C. The government should be directed to provide an informational outline within 90 days, because an informational outline is essential to enabling the defendant to prepare to meet the government's aggravation case at the sentencing phase and the court to carry out its gatekeeping duties. A number of district courts have ordered such an outline to be provided well before trial begins. See, for example, United States vs. Gendron, 2024 WL 3,647,779, at star 6, informational outline to be provided in approximately 1 month after the order and approximately 1 year before jury selection. Burkhalter, No. 1836, Letter from Government to Defense, WDMO, October 13, 2021, ordered informational outline provided by government while no trial date pending. Trial subsequently scheduled for 2 years later, in 2023, United States vs. Schlesinger, No. CR 18-2719, ECF number 432, Dieras, June 3, 2022, outline due July 28, 2022, in anticipation of trial date 6 months later, in January 2023, CECF number 220, United States vs. Duran Gomez, No. H10 459, ECF number 529, SD Tax, February 24, 2020, government provided ordered outline while no trial date pending. Trial subsequently scheduled for 2 years later, in 2022, Con UI, 2016 WL 9,331,115, star 1, government provided ordered outline on February 25, 2016, in anticipation of trial date 7 months later, in September 2016, CECF number 864 at 3, ECF No. 922, at 11, PLO, 2013 WL 1,673,109, at star 4, 6, government ordered to produce outlines of victim impact and other aggravators by August 5, 2013, in anticipation of trial date 4 months later, December 1, 2013, Lujan, 530 F sub 2D at 1271.72. Government ordered to produce outline within reasonable time and revised outline by March 24, 2011 for trial date 3 months after that, in June 2011. Requiring production of an informational outline within 90 days would in no way be burdensome or prejudicial to the government. Presumably it already has the information necessary for such an outline in its possession, because due process requires that such information be presented to the grand jury. Moreover, the memorandum the government submitted to the capital case committee in accordance with the Justice Manual's procedures presumably included the information sought. Because Justice Department procedures require that such a memorandum include an analysis of the applicable statutory aggravating factors and a discussion of victim impact evidence, see Justice Manual, Section 9 to 10.080, A, 4, 6, and 7. Local prosecutors and Department of Justice must inquire into and consider, among other factors, background of the victim, views of the victim's family, and other victim impact evidence. It is true that, in some cases, including the last one tried in this circuit, SAPOV, SDNY, the government provided its informational outline nearer in time to the start of trial, but a close look at that case shows it actually supports Mr. Mangione's request for an earlier deadline. First, the scheduling of the informational outline there was highly idiosyncratic. The government initially promised to provide it 2 months after the defense first asked for one. See United States vs. Sapov, number 117 CR 722, ECF No. 287, number 300 at 8, SDNY 2020. But this never occurred, apparently because the prosecution was largely suspended due to the pandemic. When the defense next raised the issue in August 2022, ECF number 462, 2 months before jury selection was set to begin, the court ordered the government to produce the outline by the following month, ECF number 482, rather than on the eve of voir dire as the government sought, ECF number 472 at 29. Second, the government's principal argument for delaying the informational outline in Sapov was that the case was different from most, or all, other capital cases cited by the defendant owing to the government's early full disclosure of extensive witness statements that included victim and survivor impact witnesses, whom the government had repeatedly interviewed, which interviews it had memorialized in detail. ECF number 472 at 34-35. No such disclosure has occurred in this case. Finally, it appears that the delay in production of the informational outline in Sapov until a month before the start of jury selection created serious and unnecessary logistical problems for the parties by forcing the extensive litigation over the aggravating factors and evidence to play out while the trial was in progress, with numerous late-night filings, early morning conferences, and extemporaneous rulings from the bench, especially as to the victim impact aggravator. See, for example, ECF numbers 622, 627, 691, 698, 704, 707, 725, 730, 731, 732, 733, 735, 737, 739, 741, 742, 747, 749, 751, 753, 780. This court can and should avoid the pitfall by ordering earlier production of an informational outline, which in turn will allow for litigation over the impact aggravators to occur in the pre-trial process. 3. Conclusion: for the foregoing reasons, and pursuant to the 5th, 6th and 8th Amendments to the United States Constitution and the Federal Death Penalty Act, the defendant requests that this court grant this motion for an informative outline of aggravating factors as described above, dated July 25th, 2025, New York, New York.
So basically that was the document from Luigi Mangione's legal team in New York. Prosecutors to actually find the actual proof to have the death penalty put on Luigi Mangione, because for such a long time the death penalty was literally placed up in the air and not really finalized. It's like it was a publicity stunt to launch someone's Instagram. Remember that? Basically, the prosecutors have 90 days to have an answer to basically this motion. And basically, the date the prosecutors are meant to reply by, it is on October 24th, 2025. And in the document, it's also mentioned it's not meant to take that long to basically have that finalized, saying yes, this will happen, and then starting the procedures, if that makes sense. So, 90 days. We'll see what they say in 90 days. Also, like I mentioned in my last video, when we were looking at a lot of the other documents, I can't remember which one, I'm sorry. I've read so many documents with this case. I can't keep track of them all, but it is all stored in my stupid little head. Anyway, so, and if you guys remember in a couple of documents ago, where it basically shows evidence of what things need to happen to have the death penalty put on someone, and nothing the prosecutors allegedly have on Luigi Mangione actually proves to have the death penalty put on someone. If you guys remember that, I certainly do. Again, I don't remember which document. I've read so many documents for this case in the last 3 months. I can't believe I've been doing this for 3 months. Oh my god, Luigi. One of the things was brought up in the document, basically saying that one of the things that should not have the death penalty put on Luigi Mangione is because they never followed any of the protocols to have the death penalty put on someone. Like we've seen before, it takes years and years and years to have the death penalty put on someone because they have to do interviews, family members, friends, acquaintances, neighbors, teachers, etc. for the death penalty to be put on someone. And when this was announced, none of that was actually done whatsoever. Again, I do very much feel like this was just a publicity stunt to launch someone's Instagram page. I meant to say judge in that bit, but like, again, I don't care enough about her to remember. I think she's in a bit of hot water at the moment, I think last time I heard about her, so. And also the court expressed they want to have the trial in 2026. Basically, them not finalizing this death penalty charge they have against Luigi Mangione that they want to do, and having it up in the air for such a long time, it does make it harder for Luigi Mangione's legal team to fight those charges because it is not finalized again, and for them to push it back any further, it is not fair. So this line I actually really liked when I was reading the document, and I do very much agree with this. Basically, the indictment and also the notice intent the prosecutors have to put against Luigi Mangione are very much just bare-boned to actually have the death penalty put on Luigi Mangione, basically meaning what they're claiming Luigi Mangione did and the reasons why they want to put the death penalty on Luigi Mangione, like literally nothing. And like we've seen, they're very much digging up for scraps to have anything against Luigi Mangione at this point in time. We've seen it time and time and time again. I will talk about that in more detail near the end of the video, of how much the prosecutors are literally doing that. But again, later on in the video, probably near the end. But again, I really like that line. Basically, the prosecutors who want to put the death penalty on Luigi Mangione, they don't have anything to put on Luigi Mangione that is finalized and set in stone to place the death penalty against Luigi Mangione, and I've noticed that quite a bit over the last couple of months reading these documents. You guys have probably noticed that too, and their reasoning to say, oh, this will happen again if we don't sentence Luigi the death penalty, it's basically non-existent. Basically reasons why they want to like put the death penalty on Luigi Mangione, it's very like generalized and not really facts for like basically have the death penalty put on Luigi Mangione, and it would make it harder for Luigi's legal team to actually have to fight those charges if it is not lawful or generalized or anything like that. It's very like vague, if that makes sense, when it's not meant to be vague. The death penalty, it's a big thing. It's not like a vague thing to put on someone, and it shouldn't really exist if it's like vague reasons why they want to put the death penalty on someone. And basically one of the vague reasons why they want to put the death penalty on Luigi Mangione, the prosecutors are saying, is the risk of dangerousness. It does not sound like a real word every time I say that. The beauties of the English language. Yay. The risk of dangerousness against Brian Thompson's family members, co-workers, etc. And it is very vague. It isn't like set in stone why they think that. Again, it's very vague, the reasons why they want to put the death penalty against Luigi Mangione, and when it's not meant to be vague. So basically this was also brought up in the document. Basically another reason why they want to put the death penalty against Luigi Mangione is because they thought he started a movement and also made a homemade gun and also intended to flee the state, and those are the reasons why they want to put the death penalty against Luigi Mangione. And again, it's very vague, it's not anything like set in stone, and basically this was also brought up in the document, and they're intending to make this case go as fast as possible. We've seen it a couple of times in the last couple of videos I mentioned it. They do want to make this case go as quickly as possible, and in the document it is mentioned 42 months after the indictment, but they are trying to move this as fast as possible to have this done on the 5th of December 2025. Basically, the prosecutors want this case done and dusted as quickly as possible. Like I mentioned before, it's like they're trying to cover up stuff. Allegedly, please don't sue me, I'm scared. But I do really like that was also brought up in the document when noticing it. I've noticed it quite a bit. Basically, they've been trying to make this go as quickly as possible compared to, like, say, if this is like a regular, normal case of someone killing someone. This would not be moving as fast if they wanted it to. And basically, them not having it finalized before October 24th, it basically makes it harder for Luigi to look at all the evidence and everything they have against him to have that death penalty put on Luigi Mangione for basically them only knowing the bare bone reasons why they want to put the death penalty against Luigi Mangione, and that is not right whatsoever. How the hell can you defend yourself on bare bone terms? I really like that. I want to keep using that in day-to-day life. It's a little bit dark, but they do make a really good point about that in the document. So like I mentioned before, it's like the prosecutors are pulling teeth, basically making everything really painful and slowly for the Luigi Mangione's defense to have things so they can basically do their job correctly. And it's very true. In the document they actually say the prosecutors are just basically making everything like a scavenger hunt, when in reality it's not meant to be like that. And I really like they mentioned that, because it very much has been a scavenger hunt for Luigi Mangione's legal team, for them getting things out of the prosecutors and for them to do their job correctly. Basically, the prosecutors and the government failed to prove Luigi Mangione planned and construed this entire thing whatsoever. They basically failed to prove that whatsoever. Why? And I do find it interesting they did make a point out of this, why is this so different compared to other cases where someone fled the scene by going to a different state? Why is this one so different and so big compared to this? I think it's because it is a rich white guy. I think that's the reason, and how publicized this entire thing and how much it actually blew up. Maybe because it's caused such an outcry, this entire thing. Maybe that's why. Maybe it's because it's popular on the internet. I think it's also because they think he's a little bit cute. I think that's why they're a little bit jealous of him. I don't know, but maybe that's the reason why they want to put these massive, big, scary charges against Luigi Mangione, make this as showy and flashy as much as possible. Basically, they don't really have anything to have this put on Luigi Mangione. And also, this kind of also reminds me, I'll put the case on this week's episode if you guys want to check it out, where basically this guy basically had a list, and he hunted down politicians. Luckily, one of them survived and they caught the guy, but basically this guy had a list of people he wanted to kill that were in power, and he got a slap on the wrist compared to Luigi Mangione, where he allegedly shot Brian Thompson. They think they caught the right guy compared to this other guy who actually did this. He had a list and everything. Luigi Mangione is being overcharged. Why is Luigi Mangione having all these charges put on him compared to this other guy where he literally was a threat, compared to Luigi Mangione who allegedly did this? Something to chew on, I think. So this is another document from Luigi Mangione's legal team. I don't truly understand this document. I think this is another person they're adding to their team for the death penalty charges and all that to help them out. I did try to read it. I did try to deconstruct it to make it understandable. I did not understand. Maybe someone out there who has a legal brain who understands this will get it. But I do feel like this is relevant, but I won't break this down because I don't understand. I'm sorry, I have a film degree, not a law degree. Anyway, I'll put it on screen for you guys.
Declaration of Matthew Rubenstein regarding preparation time in cases authorized for the death penalty. 1. I am a Capital Resource Counsel attorney in the Federal Public Defender Program and a member of the Federal Capital Trial Project. The Capital Resource Counsel and the Federal Death Penalty Resource Counsel, FDPRC, projects comprise the Federal Capital Trial Project, or Trial Project, one established in early 1992. A core function of the Trial Project is to provide consultation, training, and assistance to counsel and courts to improve the quality of representation and the cost effectiveness of defense services in federal capital prosecution cases. 2. I joined the Trial Project in 2010 as a Capital Resource Counsel attorney, was the director of the Capital Resource Counsel, CRC, project from 2015 to 2025, and recently transitioned back to an attorney position. The trial project is funded and administered by the Defender Services Office of the Administrative Office of the United States Courts too. My responsibilities in the Federal Capital Trial Project include the monitoring of all federal capital prosecutions throughout the United States to assist in the delivery of adequate 1. The trial project assigns a CRC or FDPRC attorney to work with the defense team in every federal capital eligible case as a resource counsel. In their role as resource counsel, the CRC attorneys, full-time salaried federal defender staff, and FDPRC attorneys, part-time contractors, are not counsel of record. Rather, they provide advice, assistance, and helpful information and resources to the defense team. In addition to their work as resource counsel, the CRC attorneys often serve as death-qualified learned counsel as part of their project responsibilities, and the FDPRC attorneys are often appointed to serve as learned counsel as CJA counsel outside their role with the project too. The work of the trial project is described in a report prepared by the Subcommittee on Federal Death Penalty Cases, Committee on Defender Services, Judicial Conference of the United States, Federal Death Penalty Cases, Recommendations Concerning the Cost and Quality of Defense Representation, May, 1998, at 28:30. The subcommittee report urges the judiciary and counsel to maximize the benefits of the Federal Death Penalty Resource Counsel project, which has become essential to the delivery of high-quality, cost-effective representation in death penalty cases. ID, at 50, an update to the report states, many judges and defense counsel spoke with appreciation and admiration about the work of resource counsel. Judges emphasized their assistance in recruiting and recommending counsel for appointments and their availability to consult on matters relating to the defense, including case budgeting. Defense counsel found their knowledge, national perspective, and case-specific assistance invaluable. Report to the Committee on Defender Services, Judicial Conference of the United States. Update on the cost and quality of defense representation in federal death penalty cases, September 2010, at 63. Defense services to indigent capital defendants in such cases. This effort includes overseeing the collection of data on the initiation and prosecution of federal capital cases. 3.3. Pursuant to these responsibilities, I have compiled the information in Exhibit A regarding proceedings in federal capital cases. In the regular course of the business of the Federal Capital Trial Project, 42 defendants were authorized for a capital prosecution and began a federal capital trial since 2010. From this group, 5 cases were excluded from the time calculation because of extended delays in the cases caused by a retrial or the COVID pandemic. 4.4. The average time between the capital indictment and the authorization of a capital prosecution by the Attorney General is 14 months. The average time between the authorization of a capital prosecution and the start of trial is 28 months. The average time between the capital indictment and the start of trial is 42 months. I declare under penalty of perjury under the laws of the United States of America, 28 U.S.C. Servern Turin 46, that the foregoing is true and correct. Executed this 22nd day of July, 2025, /S/Matthew Rubenstein 3. In order to carry out the duties entrusted to me, I rely on the data gathered by Kevin McNally, who served as resource counsel with FDPRC since the inception of the trial project in January 1992, served as the director of FDPRC between 2007 and 2018, and continued overseeing the collection of data on the initiation and prosecution of federal capital cases until 2024, when I took over this responsibility. This information is gathered from a variety of sources, including PACER case dockets and case filings, transcripts, the Administrative Office of the United States Courts, Department of Justice press releases, Federal Defender Offices and CJA Counsel, and information gathered and received from Federal Capital Trial Project Resource Counsel. This information is regularly updated and checked for accuracy. The project's information regarding federal capital prosecutions has been relied upon by the Administrative Office of the United States Courts, by the Federal Judicial Center, and by various federal district courts. 4 these cases involved a retrial, George Lecco, number 205CR00107, SDW VAR, Ronald Wilson, number 104CR1016 NGG, EDNY, and Gary Lee Sampson, number 101CR10384 LTS, DMAS, and cases delayed because of the COVID pandemic. Saifullah Habibulevich Saipov, number 117CR722 VSB, SDNY, Robert Bowers, number 218CR00292 DWA, WDPA.
Hi, it's voiceover me. So this last page on the document, I'm not gonna have it read out to you because it's just a bunch of names and dates and stuff, and I think that's gonna be like really boring and repetitive. So I am just gonna leave it on screen for you guys. So if you guys want to like pause and have a read, go ahead. But I'm just not gonna have it read out to you guys. But anyway, next part on the video. The 28th of July 2025. Basically, this document is just saying the prosecutors have 30 days to respond to the motion that I just showed you guys before. So basically, the prosecutors have like 30 days to like reply. So I'll put it up on screen for you guys.
U.S. Department of Justice, United States Attorney, Southern District of New York, Jacob K. Javits, Federal Building 26, Federal Plaza, 37% for New York. New York, 10278, July 28, 2025 via ECH Honorable Margaret M. Gamet, United States District Judge, Southern District of New York, 40 Foley Square, New York. New York, 10007, request granted. The government may file its response to defendant's motion filed at DKT, number 40 by August 27, 2025. So order dated July 28, 2025. Me United States versus Luigi Nicholas Mangione, 25 CR 176 MMG. Dear Judge Gamet, the government writes in connection with the defendant's motion for an informational outline of certain aggravating factors, which was filed on Friday, July 25, 2025. DKT, number 40. The government intends to oppose the defendant's motion and respectfully requests a period of 30 days to file its response. Respectfully submitted, Amanda L. Howell, attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S. Dominic A. Gentile, Jun Ziyang, Alexandra Messiter, Thomas John Wright, Assistant United States Attorneys 212-637-2200 Counsel of Record, via ECF.
The 1st of August 2025. So 2 documents came out on this day, one from Luigi Mangione's legal team in New York and another document from Luigi's legal team in Pennsylvania, mostly from Thomas Dickey. So this first document is from Luigi Mangione's legal team in New York, and this is basically Karen Agnifilo requesting the court to give Luigi Mangione a laptop. And if you guys remember at the start of the year, Karen Agnifilo did request for Luigi Mangione to have a laptop, but he was denied because of like reasons that I don't remember. It was some really dumb reasons. I remember that at the beginning of the year, but we will find out later the results for Luigi Mangione if he receives a laptop or not later on in the video. So I'll put it up on screen for you guys.
August 1st, 2025, via ECF, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York. New York, 10007 Re, United States versus Mangione, 25 CR 176, MMG. Dear Judge Garnett, we write on behalf of our client, Luigi Mangione, who is facing a death penalty in the above referenced case. To date, the government has provided counsel with nearly 7 TBs of discovery, including body-worn camera footage and other videos, to adequately prepare for trial and assist in his own defense. Mr. Mangione requires access to his discovery on a laptop at the MDC. Accordingly, counsel will provide a laptop to an outside vendor who will disable the laptop's connections to the internet, printers and wireless networks in compliance with the MDC's regulations. The laptop will then be provided to the government to upload all non-sensitive discovery before the laptop is sent to the MDC. With the consent of the government, counsel respectfully requests that this court direct the MDC to provide Mr. Mangione with the laptop prepared for him by the government. In addition, Given the volume of discovery, we request that the court also direct the MDC to allow Mr. Mangione access to the laptop 7 days a week from 8 a.m. to 4 p.m., consistent with the way the MDC allows other inmates access to their discovery laptops. Respectfully, Karen Friedman Agnifilo, Mark Agnifilo, Jacob Kaplan, Counsel for Luigi Mangione CC, Government Counsel, via ECF.
So now we are going to be moving on to the document by Thomas Dickey. I'll put it up on screen for you guys.
In the Court of Common Pleas of Blair County, Pennsylvania, Commonwealth of Pennsylvania, no CP07CR00027224-20240 TNF1009165-3 versus Luigi Nicholas Mangione Memorandum Clerk of Offense Cal 2025 August, PH2. Argument and summary. Legal authority for the physical production of the defendant in Blair County on May 2, 2025. The court issued an order finding defendant unavailable pursuant to PAR, Crim P600, because he did not waive personal appearance for proceedings and the federal authorities refused to produce defendant in person. The order directed the Commonwealth to update the court every 60 days on the availability of the defendant for personal appearance and further directed either party may preside for a hearing based upon a change in circumstances. On June 23, 2025, the court received the Commonwealth's notice of defendant's unavailability for personal appearance in the Blair County Court of Common Pleas and preside for consent to remote appearance, with attached correspondence from the United States Attorney for the Southern District of New York. The correspondence from the U.S. Attorney's Office indicated that the U.S. Attorney's Office would not agree to the transport of the defendant to Blair County, and that the defendant would remain federal custody in New York until conclusion of the federal prosecution. The letter also reflected that the U.S. Attorney would instruct the U.S. Marshals Service to not honor any writ seeking to take custody of the defendant for appearance in Blair County. On June 24, 2025, this court received the defendant's preside to schedule hearing on pre-trial motions, expressing a demand for physical appearance to participate in a scheduled hearing. On July 2, 2025, the court directed the defendant to file a memorandum providing the legal authority for the physical production of the defendant for pre-trial motions in the Court of Common Pleas of Blair County, while he, the defendant, remains subject to federal custody in New York, and where the United States Attorney has indicated its refusal to release the defendant for transport to Blair County. Defendant Mangione's right to be present in Blair County. It is well established that a defendant charged with a felony in the Commonwealth of Pennsylvania has a constitutionally protected right to be present at every stage of a trial, from the arraignment to the delivery of a verdict. See Lewis v. United States, 146 U.S. 370, 372, 1892. Our leading principle that pervades the entire law of criminal procedure is that, after indictment found, nothing shall be done in the absence of the prisoner. Brinley v. Crisp, 608 F. 2D 839, 848, 10th to 1979. See also Commonwealth v. McLaurin, 292 PA Super 392, 39596, 396, 1981. However, such right can be relinquished and can be waived by one's words or actions. See for example Illinois v. Allen, 397 U.S. 337, 344, 1970, Commonwealth v. Africa, 466 PA 603, 353A, 2D 855, 1976. In Pennsylvania, such right is reflected in PAR, Crim P1117, which provides in pertinent part, T, he defendant shall be present at the arraignment, at every stage of the trial including the impaneling of the jury and the return of the verdict, and at the imposition of sentence. Clearly, defendant Mangione in the case at bar has not waived his right to be present at any stage of the trial, including pre-trial motions, and has a constitutionally protected right to be present. Indeed, defendant asserts his constitutional right to be present, the primary custody doctrine where a defendant faces prosecution by both state and federal authorities, The primary custody doctrine determines where and how the defendant will serve any resulting sentence of incarceration. In relevant part, the doctrine provides the sovereign that first arrests an individual has primary custody over him. That sovereign's claim over the individual has priority over all other sovereigns that subsequently arrest him. The sovereign with primary custody is entitled to have the individual serve a sentence it imposes before he serves a sentence imposed by any other jurisdiction, regardless of the chronological order of sentence imposition. Williams v. FCI McKean, 2019 WL 1118057, at star 1, 3D C 2019, not reported in FedSup, citing Bowman v. Wilson, 672 F, 2D 1145, pages 1153 to 54, 3D C 1982, Harris v. Bureau of Prisons, 787 F, Sup. 2D 350, 355, WDPA 2011. Moreover, primary custody remains vested in the sovereign that first arrests the individual until its sentence expires and it releases the inmate, or until it relinquishes its priority through some other act, such as granting bail, dismissing the charges, or releasing the individual on May 2, 2025, the court issued an order finding defendant unavailable pursuant PAR, Crim P 600 because federal authorities refuse, d. to produce defendant in person. Parole, Williams, at star 1, George v. Longley, 463 F, APP apostrophe X 136, 138 N, 4, 3D C 2012, per curiam, as explicitly recognized by the Third Circuit. However, temporary transfer of a prisoner pursuant to a writ ad prosequendum does not constitute a relinquishment. Rios v. Wiley, 201 F, 3D 257,274-75, 3D Cit 2000, collecting cases, superseded on other grounds. See United States v. Saintville, 218 F, 3D 246, 249, 3D C 2000. The primary custody doctrine developed to provide different sovereigns, in this case the Commonwealth of Pennsylvania and the federal governments, with an orderly method by which to prosecute and incarcerate an individual who has violated each sovereign's laws. Ponzi v. Fessenden, 258 U.S. 254, 1922. C. E.S. Bowman, 672 F, 2D at 1153-54, George, 463 F, APP apostrophe X at 138 N, 4, 3D C 2012, Elwell v. Fisher, 716 F, 3D 477, 8th C 2013. On December 9, 2024, defendant Mangione was arrested in Altoona, Pennsylvania by local police officers, and was charged with tamper records or writing, pos instrument of crime W-int, and false identification to law enforcement officer. While being held in the Blair County Prison, he was subsequently indicted by a federal grand jury in the Southern District of New York. Upon his arrest in Altoona, Pennsylvania, defendant was in the primary custody, sometimes referred to as primary jurisdiction, of the Commonwealth of Pennsylvania. In Jones v. Warden McKean FCI, 714 Fodax 166, 3D, C 2017, unpublished and non-precedential, a Third Circuit panel concluded the petitioner had article standing to raise the primary custody question under 28 U.S.C. Section 2241 because the defendant did not wish to challenge the explicit exercise of inter-sovereign comity, but rather intends to raise an issue about the results flowing therefrom. 714 FAPP apostrophe X 166, 168 N, 6, 3D C 2017, 3.2 Any such release must be explicit rather than tacit or implied. See Schumet v. United States, 893 F, Sup 137, 142-43, NDNY, 1995, finding that local authorities relinquished primary custody by signing express waiver. 3 other courts, however, have ruled that a defendant lacks standing under Article L to invoke the primary custody doctrine. Those who assert jurisdiction, not those in their custody, are the beneficiaries of the rule allocating priority of prosecution to the sovereignty which first takes custody of a person. Bowman, 672 F. 2D at 1153. See also United States v. McCrary, 220 F. 3D 868, 870, 8th C 2000. The exercise of jurisdiction over him is solely a question to be determined between those two sovereignties, and is not subject to attack by the prisoner. See also Rawls v. United States, 166 F. 2D 532, 534, 10th C 1948. The sovereign alone may raise the objections to the interference with its rights. If the accused has violated the laws of both sovereigns, he is subject to prosecution by both, and he may not complain of or choose the manner or order in which each sovereign proceeds against him so long as his constitutional rights in each trial are not. The record in the case sub judice is unambiguous. The Commonwealth has never expressly waived primary custody of defendant, has not released defendant on parole, has not granted bail, or dismissed the charges. C. Williams, at Star 1, George, 463 F. APP'(X 136, at 138 N. 4. Thus, the defendant remains in the primary custody of Pennsylvania. Rule 600 under Pennsylvania Rule of Criminal Procedure 600, A. 2. The Commonwealth must commence trial within 365 days from the filing of a criminal complaint. Rule 600, C. 1, governs the calculation of this time period and requires that periods of delay at any stage of the proceedings caused by the Commonwealth when the Commonwealth has failed to exercise due diligence shall be included. Any other periods of delay shall be excluded from the computation. If trial is not commenced within the prescribed time, the defendant may file a motion to dismiss the charges with prejudice under Rule 600, D. 1. The burden then shifts to the Commonwealth to show, by a preponderance of the evidence, that it exercised due diligence in bringing the defendant to trial. What constitutes due diligence? Due diligence under Rule 600 is a fact-specific inquiry to be determined on a case-by-case basis. It does not require perfect vigilance and punctilious care, but it does require the Commonwealth to put forth a reasonable, good faith effort to bring the defendant to trial. See Commonwealth v. Selensky, 994A, 2D 1083, pages 1088-89, PA 2010, PAR, Crim P 600, comment. When a defendant is incarcerated in another jurisdiction and is thus unavailable, the Commonwealth may toll Rule 600 only if it demonstrates that it exercised due diligence in attempting to obtain custody of the defendant. See Commonwealth v. Plowden, 157A, 3D 933, PA, Super 2017, Commonwealth v. Booz, 953A, 2D 1263, 1273, PA, Super 2008. Due diligence includes an obligation to follow the proper legal process. Due diligence requires more than just initiating contact with the holding jurisdiction. It mandates the Commonwealth timely invoke and promptly follow the correct legal procedures to obtain custody of the defendant. In Plowden, for example, the Commonwealth was found to have exercised due diligence by promptly initiating the interstate agreement on detainers, IAD, process and maintaining communication with New York authorities. The court held that delays beyond the Commonwealth's control, once the violated, Harris v. Bureau of Prisons, BOP, Fed, 787 F sub 2D 350, 357, WDPA 2011. Any dispute over whether an inmate should be in the primary custody of either the state or federal government is a matter to be agreed upon between the two sovereigns. It is not subject to attack by the prisoner. Proper procedure was invoked, were excludable from the Rule 600 computation. See Plowden, 157A, 3D at 942-43, PAR, Crim P 600, C. 1, comment. It should be noted, however, the IAD is not applicable to federal pretrial detainees, as it applies only to defendants who have entered upon a term of imprisonment. United States v. Mauro, 436 U.S. 340, 1978. Application to Mr. Mangione's case to satisfy its due diligence obligations in the case at bar. The Commonwealth must pursue the only legally available process, a writ of habeas corpus ad prosequendum, authorized by 28 U.S.C. Section 2241, c. 5. This writ is a formal request from a state prosecutor to the federal court seeking temporary custody of a federal detainee for the purpose of prosecution in state court. The process is governed by 28 U.S.C. Section 2241, c. 5, which authorizes the federal court to issue the writ. 28 CFR 527.30-31, which details BOP procedures for transfers, and DOJ and USMS policies which clarify that the U.S. Marshals Service has discretion to honor such writs. The petition must be filed in the appropriate U.S. District Court, not a state court, and must demonstrate the necessity of the detainee's appearance. Once issued, the writ directs the U.S. Marshals to transport the detainee for the state proceeding and return them promptly to federal custody. Nor would informal communications between the Commonwealth and the U.S. Attorney's Office in the SNY satisfy the Commonwealth's due diligence obligations in this case. The Commonwealth must demonstrate that it took affirmative steps to initiate the proper writ process through federal court channels to secure Mr. Mangione's presence. Detainers are not a substitute for due diligence. In this case, the Commonwealth claims to have served a detainer on federal authorities to secure Mr. Mangione's appearance. However, as recognized by the U.S. Supreme Court in Mauro, a detainer is not the legal equivalent of a writ of habeas corpus ad prosequendum. As noted by the court, we can therefore assume that Congress was well aware of the use of such writs by the federal government to obtain state prisoners, and that when it used the word detainer, it meant something quite different from a writ of habeas corpus ad prosequendum. See Mauro, 436 U.S. 360. A detainer merely notifies the holding institution that the prisoner is wanted in another jurisdiction upon completion of their current detention. A detainer does not compel production of the prisoner, nor does it constitute action sufficient to meet the Commonwealth's burden of due diligence. See Mauro, at 361-63. Accordingly, merely serving a detainer is insufficient. Conclusion: in sum, the Commonwealth cannot claim due diligence under Rule 600 unless it timely identifies the need for custody of a defendant held in another jurisdiction, invokes the correct legal mechanism applicable to that defendant's status. For example, I.ad. for sentenced prisoners, writ of habeas corpus ad prosequendum for federal pretrial detainees, and pursues the process through proper channels, including formal filings in federal court where necessary. Nor can the Commonwealth evade its obligations by claiming Mr. Mangione's unavailability when he remains in their primary custody, despite his current physical custody in New York. Because the Commonwealth did not follow this process in Mr. Mangione's case, it has not satisfied its burden of demonstrating due diligence under Rule 600, c.1. The mere service of a detainer and informal communications simply do not meet the necessary legal standard. Tom Dickey Law Offices, P.C. Thomas M. Dickey, Esquire, Attorney for Defendant. Public Access Policy Certification. I certify that this filing complies with the provisions of the Public Access Policy of the Unified Judicial System of Pennsylvania. Case records of the appellate and trial courts that require filing confidential information and documents differently than non-confidential information and documents. Thomas M. Dickey, Esquire. In the Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania v. Luigi Nicholas Mangione, Certificate of Mailing I, Thomas M. Dickey, hereby certify that on this date, a true and correct copy of the foregoing memorandum was hand-delivered to the following parties on August 1, 2025, Peter J. Weeks, Esquire, District Attorney, Blair County Courthouse, 423 Allegheny Street, Hollidaysburg, Pennsylvania 16648. The Honorable Jackie A. Bernard, Blair County Courthouse, 423 Allegheny Street, Hollidaysburg, Pennsylvania 16648. Tom Dickey Law Offices, P.C. Thomas M. Dickey, Esquire, Attorney for Defendant, PA Supreme Court ID 41475.
basically in this document, Thomas Dickey basically explains Luigi Mangione has the right by law to appear in court in person. That is his rights to appear in court in Pennsylvania, because that is by law, that is his rights. He is allowed to do it, and if he requests, he wants to do it, he's allowed to do it. So here are some things I do want to bring up in the document that I found quite interesting, that I think you guys would find it really interesting as well. Basically, if the trial does not happen in Pennsylvania, that is scheduled because the prosecutors don't want to transport Luigi Mangione to Pennsylvania because they're being stubborn about it. Basically, Luigi Mangione's legal team in Pennsylvania and Luigi himself, they are allowed to file a motion to dismiss all charges in the Pennsylvania case because everything falls onto the prosecutors on that point, and they're allowed to do that. So it will be very interesting to see what happens in the future because of that. So this is another document from Thomas Dickey. Please take this document with a little bit of skepticism. I did get this from Reddit. Again, I say that in all my videos, but I do want to put that here is because, again, it is the internet. People can make up shit all the time. So do take this bit with a little bit of skepticism because I did get this from Reddit. Again, I do find a lot of these documents from the Luigi Mangione Reddit subs I'm in a lot more now, so I get a lot more information from different sources than the one subreddit I was in, and also Instagram and all that jazz. It does help me out a lot on my side of the world because, again, I am an Australian. There are a lot of documents I don't get access to or things because I do live in Australia, not the United States. So it does help me out quite a bit to make these videos for you guys. So I'll put it up on screen for you guys.
The 8th of January 2025 Dickey, Thomas M. Memorandum, Blair County District Attorney's Office. The 8th of January 2025 e-service served.
The 3rd of August 2025. So this isn't really relevant to his case, but I do feel like it kind of is, with information coming out about Luigi Mangione's case. So I came across this in one of the Reddit groups I'm in for Luigi Mangione's case. I don't spend that much time in this Reddit group anymore, but because it's a little bit toxic and a little bit turning into a echo chamber in there, so I don't really go in there anymore. I have other ones I go to get information and all that for Luigi Mangione's case. I've talked about it before in the past, but I did come across this in one of the Reddit threads I'm in, and I think this is very much relevant. I think there's going to be another wave of censoring the word Luigi or even Luigi Mangione on the internet, and I'll put up on screen for you guys of what this person posted. So I'll put up on screen for you guys.
More unnecessary Reddit censorship of Luigi Mangione discussions. I saw this post on another subreddit. I am not a member of it, but it came up when I searched up LM's name on Reddit, and I thought the discussion was excellent. Lots of young people talking about the folk hero status, and the majority being supportive of LM in general. It had 2K comments before it was unceremoniously shut down by the moderators. I made some comments there too about jury nullification, and overall, there seemed to be many people chiming in on the issue from many angles. It's sad to see such censorship for no reason, especially when people clearly want to talk about Luigi. I wonder which Reddit bigwig told them to shut it down. Anyways, I'll add the link, so that people can see the high engagement, especially from younger PPL.
So I'm actually glad I took a screenshot of that post when I did. I did thought it was important at the time, and I'm glad I took a screenshot of it, because when I went back to actually look at the original post got deleted by the narrators by that page, so it literally does not exist. If you guys remember at the start of the year and also late last year when this all happened, when basically every single social media platform censored the word Luigi, when you said the word Luigi, even when you just mentioned the Mario brother character Luigi, your page would have been taken down, your account got blocked. That happened on so many different social media platforms. That also even happened to me when I first started doing this. One of my very first short form videos got taken down because I mentioned the word Luigi. Don't worry, we fixed that. Censorship of Luigi when this all happened. That kind of luckily died down, and we have a little bit of more freedom of speech to talk about it, and also we worked ways around it. I do feel like there's going to be another wave of censoring the word Luigi or Luigi Mangione online but I think this one's going to be way more quieter than it did at the beginning when this all started, and I'm a little bit worried about that because I think it's going to make it harder to get the accurate information of what's actually going on with Luigi Mangione's case, and the control of the media that very much does not like Luigi Mangione. If you watch any mainstream media about him or anything what's going on with his case, even with social media platforms censoring Luigi Mangione's name and the word just Luigi, I don't think too many people will actually notice it compared to at the beginning when this all started, when the censoring started happening. And that's a little bit worrying about getting accurate information that's going to come out with Luigi Mangione's case and keeping it straight, instead of just letting the media fully control the information that's given to us, instead of getting the actual facts and what's happening with this case. Because I think you guys have noticed, and I very much noticed this at the very, very beginning, when the reason why I started this entire podcast thing about Luigi Mangione's case, the media does not like Luigi Mangione whatsoever, and they do not give out the most accurate information whatsoever about what's actually happening with his case, compared to some other people out there like Status Quo News. They actually get the accurate information with Luigi Mangione's case out there, compared to make it really biased compared to mainstream media. So I am a little bit worried about that, where it's going to be harder to get accurate information what's actually happening with his case. But I'm going to keep talking about Luigi Mangione. I'm going to keep making these videos talking about Luigi Mangione and getting the accurate information out for you guys. But I did feel like I needed to talk about this because I do feel like it might be coming up again, the censoring of Luigi Mangione's name, and that's going to make it harder to spread information about Luigi Mangione and what's actually happening with his case. So I'm not going to stop talking about him. I'm not going to stop talking about his case. I'm going to keep making these videos talking about the accurate information on his case. Okay, now we are moving on to something else. The 4th of August 2025. This is a document from Karen Agnifilo, like earlier that I showed you, where Karen Agnifilo requested Luigi Mangione can have a laptop, and this is the response to that by the government. So I'll put it up on the screen for you guys.
August 1st, 2025 request granted. The MDC is hereby ordered to provide Mr. Mangione with the laptop prepared by the government, with access to it 7 days a week from 8:00 via ECF. The Honorable Margaret M. Gamet, United States District Judge, Southern District of New York, 40 Foley Square, New York, 10007 AM to 4 p.m. If the access needs modification for operational or security reasons, MDC officials may request such modification through the government. The Clerk of Court is respectfully directed to terminate DKT No. 43. So order dated August 4th, 2025 United States v. Mangione, 25 CR 176, MMG. Dear Judge Gamet, we write on behalf of our client, Luigi Mangione, who is facing a death penalty in the above referenced case. To date, the government has provided counsel with nearly 7 TBs of discovery, including body-worn camera footage and other videos, to adequately prepare for trial and assist in his own defense. Mr. Mangione requires access to his discovery on a laptop at the MDC. Accordingly, counsel will provide a laptop to an outside vendor who will disable the laptop's connections to the internet, printers and wireless networks in compliance with the MDC's regulations. The laptop will then be provided to the government to upload all non-sensitive discovery before the laptop is sent to the MDC. With the consent of the government, counsel respectfully requests that this court direct the MDC to provide Mr. Mangione with the laptop prepared for him by the government. In addition, given the volume of discovery, we request that the court also direct the MDC to allow Mr. Mangione access to the laptop 7 days a week from 8 a.m. to 4 p.m. consistent with the way the MDC allows other inmates access to their Discovery laptops. Respectfully, Karen Friedman Agnifilo, Mark Agnifilo, Jacob Kaplan, counsel for Luigi Mangione said, Government Counsel, via ECE.
So I remember when this came out, this was like a big win. That was a good day, honestly. Like, there were so many people like, yes, Luigi got a win. So everyone was like very excited. I'm also included, so I'm glad Luigi Mangione was able to get a laptop to look at all the evidence and everything the prosecutors have against Luigi Mangione, and he's allowed to see it now, finally. So I'm so glad this was granted. So yay, win for Luigi. The 5th of August 2025. This is a document from Thomas Dickey. I did get this from Reddit, so do take it with a little bit of skepticism. I also do want to add this here because I don't want to keep saying that 50 million times going forward. Going forward with all these documents I'm going to show you, all of these I did get offline, like in different Reddit groups and also from Instagram, so do take it with a little bit of skepticism, but they do look quite accurate, and but again, do take it with a little bit of skepticism because again, I did get them from the internet instead of from official sources that I sadly, some of them I can't access because of my side of the world. I'll put this document up on screen for you guys.
File copy in the Court of Common Pleas of Blair County, Pennsylvania, Commonwealth of Pennsylvania, OTNF 1009165-3 versus Luigi Nicholas Mangione, Clerk of Offense 20Z, the 5th of August, PM2, Memorandum Argument and Summary, Legal Authority for the Physical Production of the Defendant in Blair County on May 2, 2025. The court issued an order finding defendant unavailable pursuant to PAR, Crim P600, because he did not waive personal appearance for proceedings and the federal authorities refused to produce defendant in person. The order directed the Commonwealth to update the court every 60 days on the availability of the defendant for personal appearance, and further directed either party may preside for a hearing based upon a change in circumstances. On June 23, 2025, the court received the Commonwealth's notice of defendant's unavailability for personal appearance in the Blair County Court of Common Pleas and preside for consent to remote appearance, with attached correspondence from the United States Attorney for the Southern District of New York. The correspondence from the U.S. Attorney's Office indicated that the U.S. Attorney's Office would not agree to the transport of the defendant to Blair County, and that the defendant would remain federal custody in New York until conclusion of the federal prosecution. The letter also reflected that the U.S. Attorney would instruct the U.S. Marshal's Service to not honor any writ seeking to take custody of the defendant for appearance in Blair County. On June 24, 2025, this court received the defendant's preside to schedule hearing on pre-trial motions, expressing a demand for physical appearance to participate in a scheduled hearing. On July 2, 2025, the court directed the defendant to file a memorandum providing the legal authority for the physical production of the defendant for pre-trial motions in the court of, while he, the defendant, remains subject to federal custody in New York, and where the United States Attorney has indicated its refusal to release the defendant for transport to Blair County. Defendant Mangone's right to be present in Blair County. It is well established that a defendant charged with a felony in the Commonwealth of Pennsylvania has a constitutionally protected right to be present at every stage of a trial, from the arraignment to the delivery of a verdict. See Lewis v. United States, 146 U.S. 370, 372, 1892. A leading principle that pervades the entire law of criminal procedure is that, after indictment found, nothing shall be done in the absence of the prisoner. Brini v. Crisp, 608 F. 2D 839, 848, 10th to 1979. See also Commonwealth v. McLaurin, 292 PA Super 392, 395-96, 396, 1981. However, such right can be relinquished and can be waived by one's words or actions. See for example Illinois v. Allen, 397 U.S. 337, 344, 1970, Commonwealth v. Africa, 466 PA 603, 353A, 2D 855, 1976. In Pennsylvania, such right is reflected in PAR, CRIMP 1117, which provides in pertinent part, t. He defendant shall be present at the arraignment, at every stage of the trial including the impanelling of the jury and the return of the verdict, and at the imposition of sentence. Clearly, defendant Mangione in the case at bar has not waived his right to be present at any stage of the trial, including pre-trial motions, and has a constitutionally protected right to be present. Indeed, defendant asserts his constitutional right to be present. The primary custody doctrine, where a defendant faces prosecution by both state and federal authorities, the primary custody doctrine determines where and how the defendant will serve any resulting sentence of incarceration. In relevant part, the doctrine provides the sovereign that first arrests an individual has primary custody over him. That sovereign's claim over the individual has priority over all other sovereigns that subsequently arrest him. The sovereign with primary custody is entitled to have the individual serve a sentence it imposes before he serves a sentence imposed by any other jurisdiction, regardless of the chronological order of sentence imposition. Williams v. FCI McKean, 2019 WL 1118057, at star 1, 3D C 2019, not reported in FedSup, citing Bowman v. Wilson, 672 F, 2D 1145, pages 1153 to 54, 3D C 1982, Harris v. Bureau of Prisons, 787 F, Sup. 2D 350, 355, WDPA 2011. Moreover, primary custody remains vested in the sovereign that first arrests the individual until its sentence expires and it releases the inmate, or until it relinquishes its priority through some other act, such as granting bail, dismissing the charges, or releasing the individual on May 2, 2025, the court issued an order finding defendant unavailable pursuant PAR, CRIMP 600 because federal authorities refuse, d. to produce defendant in person. At star 1, George v. Longley, 463 F, APP'(X 136, 138 N, 4, 3D C 2012, per curiam 2 as explicitly recognized by the Third Circuit. However, temporary transfer of a prisoner pursuant to a writ ad prosequendum does not constitute a relinquishment. Rios v. Wiley, 201 F, 3D 257, 274-75, 3D Cit 2000, collecting cases, superseded on other grounds. See United States v. Saintville, 218 F, 3D 246, 249, 3D C 2000. The primary custody doctrine developed to provide different sovereigns, in this case the Commonwealth of Pennsylvania and the federal governments, with an orderly method by which to prosecute and incarcerate an individual who has violated each sovereign's laws. Ponzi v. Fessenden, 258 U.S. 254, 1922. See, for example, Bowman, 672 F, 2D at 1153-54, George, 463 F, APP'(X at 138 N, 4, 3D C 2012, Elwell v. Fisher, 716 F, 3D 477, 8th C 2013. On December 9, 2024, defendant Mangione was arrested in Altoona, Pennsylvania by local police officers, and was charged with tamper records or writing, pos instrument of crime W-int, and false identification to law enforcement officer. While being held in the Blair County Prison, he was subsequently indicted by a federal grand jury in the Southern District of New York. Upon his arrest in Altoona, Pennsylvania, defendant was in the primary custody, sometimes referred to as primary jurisdiction, of the Commonwealth of Pennsylvania. In Jones v. Warden McKean FCI, 714 FedEx 166, 3D, C 2017, unpublished and non-precedential, a Third Circuit panel concluded the petitioner had Article I standing to raise the primary custody question under 28 U.S.C. Section 2241 because the defendant did not wish to challenge the explicit exercise of inter-sovereign comity, but rather intends to raise an issue about the results flowing therefrom. 714 FAPP'(X 166, 168 N, 6, 3D C 2017.3. Any such release must be explicit rather than tacit or implied. See Schumet versus United States, 893 F. Sub 137, 142-43, NDNY, 1995, finding that local authorities relinquished primary custody by signing express waiver. 3 other courts, however, have ruled that a defendant lacks standing under Article 3 to invoke the primary custody doctrine. Those who assert jurisdiction, not those in their custody, are the beneficiaries of the rule, allocating priority of prosecution to the sovereignty which first takes custody of a person. Bowman, 672 F. 2D at 1153. See also United States versus McCrary, 220 F. 3D 868, 870, 8th C 2000. The exercise of jurisdiction over him is solely a question to be determined between those two sovereignties, and is not subject to attack by the prisoner. See also Rawls versus United States, 166 F. 2D 532, 534, 10th C 1948. The sovereign alone may raise the objections to the interference with its rights. If the accused has violated the laws of both sovereigns, he is subject to prosecution by both, and he may not complain of or choose the manner or order in which each sovereign proceeds against him so long as his constitutional rights in each trial are not. Sub judice is unambiguous. The Commonwealth has never expressly waived primary custody of defendant, has not released defendant on parole, has not granted bail, or dismissed the charges. See Williams, at *1, George, 463 F. APP'*X 136, at 138 N. 4. Thus, the defendant remains in the primary custody of Pennsylvania. Rule 600 under Pennsylvania Rule of Criminal Procedure 600, A. 2. The Commonwealth must commence trial within 365 days from the filing of a criminal complaint. Rule 600, C. 1, governs the calculation of this time period and requires that periods of delay at any stage of the proceedings caused by the Commonwealth when the Commonwealth has failed to exercise due diligence shall be included. Any other periods of delay shall be excluded from the computation. If trial is not commenced within the prescribed time, the defendant may file a motion to dismiss the charges with prejudice under Rule 600, D1. The burden then shifts to the Commonwealth to show, by a preponderance of the evidence, that it exercised due diligence in bringing a defendant to trial. What constitutes due diligence? Due diligence under Rule 600 is a fact-specific inquiry to be determined on a case-by-case basis. It does not require perfect vigilance and punctilious care, but it does require the Commonwealth to put forth a reasonable, good faith effort to bring the defendant to trial. See Commonwealth v. Selensky, 994A, 2D 1083, pages 1088-89, PA 2010, PAR, Crim P 600, comment. When a defendant is incarcerated in another jurisdiction and is thus unavailable, the Commonwealth may toll Rule 600 only if it demonstrates that it exercised due diligence in attempting to obtain custody of the defendant. See Commonwealth v. Plowden, 157A, 3D 933, PA, Super 2017, Commonwealth v. Booz, 953A, 2D 1263, 1273, PA, Super 2008. Due diligence includes an obligation to follow the proper legal process. Due diligence requires more than just initiating contact with the holding jurisdiction. It mandates the Commonwealth timely invoke and properly follow the correct legal procedures to obtain custody of the defendant. In Plowden, for example, the Commonwealth was found to have exercised due diligence by promptly initiating the interstate agreement on detainers, IAD, process and maintaining communication with New York authorities. The court held that delays beyond the Commonwealth's control, once the violated, Harris v. Bureau of Prisons, BOP, Fed, 787 F sub 2D 350, 357, WDPA 2011, any dispute over whether an inmate should be in the primary custody of either the state or federal government is a matter to be agreed upon between the two sovereigns. It is not subject to attack by the prisoner. A procedure was invoked, were excludable from the Rule 600 computation. See Bowden 157A, 3D at 942.43, PAR, Crim P600, C. 1. Comment: it should be noted, however, the IAD is not applicable to federal pretrial detainees, as it applies only to defendants who have entered upon a term of imprisonment. United States v. Mauro, 436 U.S. 340, 1978. Application to Mr. Mangiane's case to satisfy its due diligence obligations in the case at bar. The Commonwealth must pursue the only legally available process, a writ of habeas corpus ad prosequendum, authorized by 28 U.S.C. Section 2241, c. 5. This writ is a formal request from a state prosecutor to the federal court seeking temporary custody of a federal detainee for the purpose of prosecution in state court. The process is governed by 28 U.S.C. Section 2241, c. 5, which authorizes the federal court to issue the writ. 28 CFR 527.30-31, which details BOP procedures for transfers, and DOJ and USMS policies which clarify that the U.S. Marshals Service has discretion to honor such writs. The petition must be filed in the appropriate U.S. District Court, not a state court, and must demonstrate the necessity of the detainee's appearance. Once issued, the writ directs the U.S. Marshals to transport the detainee for the state proceeding and return them promptly to federal custody. Nor would informal communications between the Commonwealth and the U.S. Attorney's Office and the SDNY satisfy the Commonwealth's due diligence obligations in this case. The Commonwealth must demonstrate that it took affirmative steps to initiate the proper writ process through federal court channels to secure Mr. Mangiane's presence. Detainers are not a substitute for due diligence. In this case, the Commonwealth claims to have served a detainer on federal authorities to secure Mr. Mangiane's appearance. However, as recognized by the U.S. Supreme Court in Mauro, a detainer is not the legal equivalent of a writ of habeas corpus ad prosequendum. As noted by the court, we can therefore assume that Congress was well aware of the use of such writs by the federal government to obtain state prisoners, and that when it used the word detainer, it meant something quite different from a writ of habeas corpus ad prosequendum. See Mauro, 436 U.S. 360. A detainer merely notifies the holding institution that the prisoner is wanted in another jurisdiction upon completion of their current detention. A detainer does not compel production of the prisoner, nor does it constitute action sufficient to meet the Commonwealth's burden of due diligence. See Mauro, at 361-63. Accordingly, merely serving a detainer is insufficient. In sum, the Commonwealth cannot claim due diligence under Rule 600 unless it timely identifies the need for custody of a defendant held in another jurisdiction, invokes the correct legal mechanism applicable to that defendant's status, for example, IAD for sentenced prisoners, writ of habeas corpus ad prosequendum for federal pretrial detainees, and pursues the process through proper channels, including formal filings in federal court where necessary. Nor can the Commonwealth evade its obligations by claiming Mr. Mangiane's unavailability when he remains in their primary custody, despite his current physical custody in New York. Because the Commonwealth did not follow this process in Mr. Mangiane's case, it has not satisfied its burden of demonstrating due diligence under Rule 600, c. 1. The mere service of a detainer and informal communications simply do not meet the necessary legal standard. Thomas Dickey, Esquire, Attorney for Defendant. Certification. I certify that this filing complies with the provisions of the public access policy of the Unified Judicial System of Pennsylvania. Case records of the appellate and trial courts that require filing confidential information and documents differently than non-confidential information and documents. Hallery Thomas Dickey, Esquire, County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania versus Luigi Nicholas Mangione, CP 07CR0002724-2024. Certificate of Mailing 1, Thomas Dickey, hereby certify that on this date, a true and correct copy of the foregoing memorandum was hand-delivered to the following parties on August 1, 2025. Peter J. Weeks, Esquire, District Attorney, Blake County Courthouse, 423 Allegheny Street, Hollidaysburg, Pennsylvania 16648. The Honorable Jackie A. Bernard, Blair County Courthouse, 423 Allegheny Street, Hollidaysburg, Pennsylvania 16648. Tom Dickey, Law Officers, PC, Thomas M. Dickey, Esquire, Attorney for Defendant, PA Supreme Court ID 41475.
Basically, this document is just Thomas Dickey reconfirming Luigi Mangione has the right to show up in Pennsylvania in person because of his rights. This is just reconfirming he does have the right to show up in person in Pennsylvania. The 6th of August, 2025. So I'll put up on screen for you guys.
In the Court of Common Pleas of Blair County, Pennsylvania of Commonwealth of Pennsylvania, number 2024 CR 2724 versus Luigi Nicholas Mangione, Hon Jackie Atherton Bernard Pete Weeks, Esquire Nicole Smith, Esquire Thomas Dickey, Esquire 656. Presiding Judge Patton, District Attorney, First Assistant District Attorney Counsel for Defendant Order. And now, this 2nd day of July, 2025, entry of the following order is deemed appropriate. It is hereby ordered, directed, and decreed that 1. On May 2nd, 2025, the court issued an order finding defendant unavailable pursuant to PAR, Crim P. 600 because he did not waive personal appearance for proceedings and the federal authorities refused to produce defendant in person. The order directed the Commonwealth to update the court every 60 days on the availability of the defendant for personal appearance, and further directed either party may preside for a hearing based upon a change in circumstances. 2. On June 23, 2025, the court received the Commonwealth's notice of defendant's unavailability for personal appearance in the Blair County Court of Common Pleas and preside for consent to remote appearance, with attached correspondence from the United States Attorney for the Southern District of New York. Said correspondence stated, the defendant remains available for remote appearances in Blair County. The retention of custody over the defendant continues until conclusion of the federal prosecution, and the instruction to the United States Marshals to not honor any writ seeking to take custody of the defendant for appearance in Blair County. On June 24, 2025, this court received the defendant's preside to schedule hearing on pretrial motions, expressing a demand for physical appearance to participant in a scheduled hearing. A clear reading of the above-referenced filings by the parties indicate there is no change in circumstances, either in the position of the federal authorities or the defense from the time of the issuance of May 2, 2025 order. The defense is directed to file a memo within 30 days, providing the legal authority for the physical production of the defendant for pretrial motions in the Court of Common Pleas of Blair County, Pennsylvania, while he remains subject to federal custody and pending prosecution when the United States Attorney has specifically stated its refusal to release the defendant for transport to Blair and or agrees to make him available for virtual participation. The Commonwealth shall file a response to the defense memorandum within 30 days of receipt of the defense memorandum. Counsel is reminded that courtesy copies of all filings shall be provided to chambers contemporaneously with filing the same of record. Consistent with this court's prior May 2, 2025 order, the Commonwealth has an ongoing duty to update the court every 60 days to indicate defendant's status with the federal authorities and whether his personal appearance can be secured in cooperation with those federal authorities. Again, as stated in May 2, 2025 order, either party may file a preside upon a change of circumstances, requesting the court to schedule a proceeding. Emphasis added. However, it is further directed that any preside specify the change in circumstances, warranting the scheduling of a court proceeding. By the court, Jackie Atherton Bernard, J.
The 8th of August 2025. This is another document by Thomas Dickey requesting for Luigi Mangione to be there in person, and also, so I'll put the document on screen for you guys.
The 8th of August 2025 petition for writ of habeas corpus ad prosequendum Dickey, Thomas M. The 8th of August 2025 e-service Blair County District Attorney's Office served.
So this document came out on the same day as the last document I just showed you guys. This is the prosecutor's response to basically when they HIPAA violations to get Luigi Mangione's medical records, and this is their response to breaking the law. So it's actually quite funny. They literally just sound like giant fucking children in this response, and it's absolutely hilarious. So I'll put it up on screen for you guys.
August 8th, 2025. The Honorable Gregory Caro, Supreme Court of the State of New York, 100 Center Street, Part 32, New York, New York 10013 Re. People v. Luigi Mangione Indictment No. IND 75657. 24. Dear Judge Caro, this letter is submitted in response to Defense Counsel's letter to the court dated July 17, 2025, wherein she claims that the People's Subpoena to Aetna Health Incorporated, Aetna, dated May 14, 2025, May 14th subpoena, was false and fraudulent, that the people violated defendants' rights under HIPAA, and that the people violated the physician-patient privilege. The 17th of July 2025 letter at 125. None of those claims withstand scrutiny, and none of them entitle defendant to any relief in this proceeding. In her letter, counsel repeatedly insists that there was something secretive or nefarious about the May 14H subpoena, but it sought nothing more from Aetna than the account number and period of time during which Luigi Mangione received coverage. That request was entirely unremarkable. To suggest otherwise is without merit or basis. In any event, May 14th subpoena was lawful and properly drafted to return production of the requested materials to New York County Supreme Court Part 32 on a date prior to trial, May 23, 2025. CPLJ 610.25 2. Explains that nothing in this article shall be deemed to prohibit the designation of a retum date for a subpoena duces tecum prior to trial. That language makes abundantly clear that subpoenas for production at court may require compliance on a date prior to the actual date for commencement of the trial, thus creating a window for analysis of the materials without the need to adjourn the trial for that purpose. 1. And while the subpoena directed Aetna to provide the materials to Part 32, when Aetna provided the materials directly to the people forwarded the materials to the court. The subpoena response thus arrived at the appropriate destination. CPL Section 610.25 Practice Commentaries by Peter Preza, explaining that his section was enacted in 1977 to legislatively overrule judicial holdings that material produced in response to a subpoena duces letum could not be retained by the issue or purpose of inspection and analysis prior to its use as evidence. These circumstances, defendant's real complaint is not about the subpoena itself, but about Aetna's response to the subpoena, which included documents that the people had not requested. When the people dutifully alerted Aetna that it had sent material that exceeded the scope of the subpoena, Aetna submitted a new response containing only the information we requested. That information consisted of nothing more than defendant's account number and dates of coverage. Defendant cites no authority to support his complaint that Danny was required to obtain a so-ordered subpoena to request that limited information. See the 17th of July 2025 letter at 136. Indeed, upon careful examination, the requested information does not appear to be protected by HIPAA, since it did not relate to a condition, treatment, or payment for health care. 45 CFR Section 160.103. The defense does not cite authority otherwise, even assuming the requested information was HIPAA protected. HIPAA specifically contemplates production in response to a non-court-ordered subpoena. 45 CFR Section 164.512 E1 v. allowing covered entity, here, Aetna, to produce fine in response to a subpoena after the covered entity gives requisite notice to individual. The people did not make any request of Aetna that they not notify the defense of the subpoena or production, nor do the people have any information about whether they did or did not. The people issued a valid subpoena to Aetna for an appropriately limited set of relevant information. Through no fault of the people, Aetna seemingly provided materials outside of the scope of the subpoena. The people then promptly identified the error and notified the court and the defense and deleted our copy of said materials. Finally, even if Aetna violated HIPAA in their production of records, the remedy would not be suppression. See People v. Marrero, 71 Miscellaneous 3D 1078, 1084, NY County 2021. Even if a subpoena violated HIPAA, the relevant records should not be suppressed at trial. See also Matter of Miguel M. v. Barron, 17 NY, 3D 37, 45, 2011. We assume it is correct that, in a criminal case, a HIPAA or privacy rule violation does not always require the suppression of evidence. United States v. Elliott, 676 F. Sup. 2D 431, 440, DMD 2009, explaining that the remedy for any HIPAA violation is against the covered entity, not the prosecution through suppression. Likewise, suppression is not required based on any supposed violation of New York's physician-patient privilege. People v. Green, 9 NY, 3D 277, 2007. Defendant is thus not entitled to any relief against the people. Defendant's claims of the people's fraudulent intent are baseless. In the course of any court proceeding, mistakes do occur. Indeed, Aetna erroneously sent us materials that exceeded the request set out in the subpoena. We undertook the appropriate measures when, too, the people had already learned of defendant's coverage with Aetna through the execution of a judicial search warrant for defendant's iCloud account. In Marrero, the court further declined to grant defendant's motion to disqualify the assistant district attorney from the case on the ground that he or she had reviewed the entirety of the medical records at issue. We realized the error. Like Aetna, the defense then erred, compounding Aetna's mistake. Defense counsel sent the people an email attaching the entire Aetna file she now complains about. Once again, we complied with our ethical obligations by asking counsel if she intended to send us the file. When she indicated that she did not and asked that we delete it, we complied with her request and did not take advantage of her error. Thus, on this and all occasions when errors were made by defense counsel and by Aetna, the people acted ethically to alert the court and counsel. The defense nonetheless seeks to punish the people for the administrative mistakes of others, claiming that the people have perpetrated a lie and a fraud against defendant, an inflammatory and dubious accusation without any basis. Reviewing the substance of what occurred, it provides no reason for the defense to delay this case from moving forward toward the hearing and trial. In sum, the people urge this court to deny defendant's application in its entirety, without a hearing and set dates for hearing and trial. Sincerely, Joel F. Seidemann, Joel J. Seidemann, Senior Trial Counsel, Assistant District Attorney.
So basically that was the document by the prosecutors, them defending themselves when basically they broke the law to get Luigi Mangione's medical records. Like I might add, we covered that in my last video, go check it out. Basically, the prosecutors did a massive fucking HIPAA violation to get Luigi Mangione's medical records from his insurance company, and they basically got everything from Luigi Mangione's his healthcare insurance, and they basically got all those documents, and basically this is them just pretending and saying, no, we definitely gave it to the court. Like, it didn't go directly to us, we definitely gave it to the court by law. Yes, we did. They fucking didn't. They did not do that whatsoever. They did not give those documents directly to the court whatsoever. They were blaming healthcare insurance people, they were blaming Luigi Mangione's legal team, they were blaming Karen Agnifilo. Like, no, it's your fucking mistake, not theirs, okay? They fucked up so hard, and they sound like giant whiny children in this document, their response, and it's like, what the fuck? The 11th of August 2025. A couple of documents did come out on this day, so I'll put them up on the screen for you guys.
The 8th of August 2025 petition for writ of habeas corpus ad prosequendum Dickey, Thomas M. The 8th of August 2025 e-service served Blair County District Attorney's Office served.
So this is another document from Thomas Dickey, so I'll put it up on screen for you guys.
In the Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania vs. CP 07CR 2724-20245 Luigi Mangione, Defendant, 386 petition for writ of habeas corpus ad prosequendum, and now comes the Commonwealth of Pennsylvania, by and through District Attorney Peter J. Weeks and First Assistant District Attorney Nicole Smith of the District Attorney of Blair County, Pennsylvania, and hereby files the instant petition for writ of habeas corpus ad prosequendum as follows: that the above-captioned defendant is a federal prisoner presently confined in the Metropolitan Detention Center located in Brooklyn, New York under registration number 52503-511 on charges of capital murder, that the said defendant has been charged in Blair County by criminal complaint filed before Magisterial District Justice Office 24 and a second, seating the Honorable Benjamin Jones. The charges include inter alia forgery, a violation of 18 PACS 4101, 3, firearms not to be carried without a license, a violation of 18 PACS C 106, 1, tampering with records or identification, a violation of 18 PACS 4104, and possession of instruments of a crime, a violation of 18 PACS NINO 07, that after the filing of the criminal complaint and contemporaneously with the waiver of his preliminary hearing, defendant waived extradition to the state of New York on December 19, 2024 after an arrest warrant was issued by the New York County Court for the charge of murder of the 1st degree. That immediately after waiving extradition, defendant was both taken into custody from the courtroom, transported directly to an airport, and flown to New York State by New York City law enforcement. That on December 19, 2024, defendant was taken into federal custody in the city and state of New York on federal charges of homicide. That defendant's Pennsylvania charges are currently pending before the Blair County Court of Common Pleas at the above-captioned docket. That the Commonwealth of Pennsylvania has lodged a detainer for defendant in New York and has been in constant communication with both the Manhattan District Attorney's Office as well as the prosecuting attorneys for the United States in the Southern District of New York. That defendant has subsequently filed a counseled omnibus pretrial motion, seeking suppression of evidence and a habeas corpus review of the instant case. That the Commonwealth has made multiple efforts to discuss with local counsel the opportunities available to allow defendant to appear virtually in Blair County. That notwithstanding the United States graciously offering to make the defendant available to Pennsylvania via video conferencing, defendant eschewed any virtual appearance options that would have precluded safety concerns for both law enforcement and the defendant himself during the physical transport, instead filing a written demand for his in-person appearance in Blair County during the litigation of the aforesaid pretrial motions. That Blair County District Attorney's Office is consequently constrained to request the production of defendant for appearance in the Blair County Court of Common Pleas for the purpose of a suppression hearing on the defendant's pretrial omnibus motions and would intend that his projected time and date of return to the United States Marshals occur immediately after conclusion of the omnibus pretrial hearing. Wherefore, your petitioner prays this honourable court to issue a writ of habeas corpus ad prosequendum, requesting that the United States Marshals Service release defendant Mangione to the custody of the Blair County Sheriff's Department and or other Blair County law enforcement who will assume full responsibility for the prisoner's custody and provide for the safekeeping, secure custody, and care of the prisoner at no cost to the federal government, GU. In order to physically produce him before the Blair County Court of Common Pleas for litigation before the court on defendant's omnibus pretrial motion, respectfully submitted, the Peter J. Weeks District Attorney Nicole M. Smith First Assistant District Attorney. In the Court of Common Pleas of Blair County, Pennsylvania Criminal Division Commonwealth of Prani Vanta CP 07 CR 2724-2024 Luigi Mangione, Defendant, Certificate of Service I, Nicole M. Smith, First Assistant District Attorney, do hereby certify that I have served on this day a true and correct copy of the foregoing memorandum of law via email and postal mail to Thomas Dickey, Esquire 308 Orchard Avenue, Altoona, Pennsylvania 16602 Law 312 at yahoo.com. Date, August 8, 2025 milliseconds. Nicole M. Smith First Assistant District Attorney, Clerk of Orphans Court Gin of Guards 2025 August, 8 p.m. 12:55 Filed Blair County Robin G. Patton.
basically, this, again, another document. A lot of these documents from Thomas Dickey are just like reconfirming Luigi Mangione is allowed to appear in court. In the document, they do say different things. I'm probably not saying it and giving it justice as much as it deserves. Sorry about that, guys. Another document by Thomas Dickey reconfirming Luigi Mangione is definitely allowed to appear in court for his Pennsylvania charges, and the prosecutors are the ones who are going to pay for it. And in this, it does show Luigi Mangione, they are going to provide the transport for Luigi Mangione to go to Pennsylvania. And this was mentioned in my last video when I mentioned all the transportation Luigi Mangione took to get from Pennsylvania to New York. Someone mentioned Luigi Mangione did take a plane, and this is just reconfirming he did take a plane. They took Luigi Mangione from Pennsylvania to New York. So thank you for that person if you're watching this. And basically, Thomas Dickey really wants Luigi Mangione to appear in court for basically habeas corpus. I'm probably saying that wrong. It's probably Latin. I should know how to say it. This channel is named after a Latin word. There you go. Fun little trivia fact. Anyway, if you guys don't know what that word means, I'll put it up on screen for you guys.
Habeas corpus is a legal procedure invoking the jurisdiction of a court to review the unlawful detention or imprisonment of an individual, and request the individual's custodian to bring the prisoner to court, to determine whether their detention is lawful.
Basically, that's what habeas corpus means if you guys didn't know, but like, now you know. The 14th of August 2025. This document literally came out yesterday when I was editing this script for this video. It literally came out yesterday for me. Basically, this is the prosecutors basically agreeing, yes, I'll send Luigi to Pennsylvania to appear in court. So I'll put the document on screen for you guys.
Pleas of Blair County, Pennsylvania, Commonwealth of Pennsylvania versus Luigi Nicholas Mangione, defendant Hon Jackie Atherton Bernard Pete Weeks, Esquire Nicole Smith, Esquire Thomas Dickey, Esquire number 2024 CR 2724 GW 123, 3 co-presiding judge 52 inches District Attorney and First Assistant District Attorney Counsel for Defendant Order. And now, this 7th day of August, 2025. The court, having conducted a telephone status conference with counsel based upon the procedural posture of the case, entry of the following order is deemed appropriate. It is hereby ordered, directed, and decreed that the Commonwealth has represented its intention to proceed with a writ of habeas corpus ad prosequendum. It is anticipated that said writ will be filed with the federal court by and through the Blair County District Attorney's Office forthwith. The Commonwealth remains under an ongoing obligation to file a notice every 60 days relative to the defendant's ability to personally appear in the Blair County Court of Common Pleas for proceedings in light of him being in federal custody. The court also reiterates that either party may file a pre-sipe upon a change of circumstances, requesting the court schedule a proceeding by the court.
Basically, this needs to be finalized by the next day, so like today as me filming this video, but we'll see in the next couple of days when this document officially comes out, and I'll bring up in my next video and all that jazz. Or like I'll post it up on my social medias. So I'll pop it on there when it actually comes out, when we receive that document. So, and then we'll cover that in my next video on Luigi. And basically, good on you, Thomas Dickey, for sticking to your guns, for not letting Luigi Mangione do these court appearances through Zoom. He's allowed to do it in person. So again, we'll see in the next couple of days when this document will come out, when they agree to it. So I'm very excited for that. So that is the most relevant information we have on Luigi Mangione's case so far as me filming this video, the 15th of August 2025. So now we are going to be moving on to my final thoughts and things that I thought that were important but weren't really relevant to Luigi Mangione's case, but I did want to add them here anyway. So I will do that now. Why did I stutter? This is like the first one. This isn't really relevant to his case, but someone very kindly DM'd me this, and I did have a look at it. It is a article online, but I didn't want to really add this to the actual like official documents and all that like beforehand, because I can't really find the official article or anything like that, and I don't want to use articles that could be biased or that aren't factual whatsoever when I do these type of videos, because again, I do really really want to get the most accurate information out and correct information out for you guys for this case, instead of like reading some article and calling it fact when it really is not. But I will put it up on screen for you guys and on the website if you guys want to go have a read of it anyway, so I'll put it on the screen for you guys. But yeah, thank you for that person for DMing me that. I do very much appreciate it. I do encourage you guys, if you have any information or anything I talk about, I do encourage you guys to like DM me or anything like that on like Instagram, preferably on this channel, not my other channels, because again, those are just for other things. Yeah, I do appreciate that, so DM me if you have any information or anything like that. I do appreciate that. It does help me out. Okay, that's like probably the only thing I kind of just wanted to add here that wasn't really relevant to this case. Sometimes I have more of those than others when I make these videos. Around I just had one, but now we are going to move on to like my final thoughts with like everything going on with Luigi Mangione's case, and I have a lot to say about it. So I do find it very interesting how much we've been seeing the prosecutors been messing up and fucking up, like even like breaking laws and all that, and I keep saying that in all my videos, but the evidence is there, like how much they fuck up. Like, it very much looks like the prosecutors are struggling to find anything to put against Luigi Mangione, and it's very interesting. Like, it kind of feels like they don't have the right guy and they don't want to admit defeat, like the 1 week manhunt they did after Brian Thompson was murdered, and I feel like they don't want to like say, oh, we made a mistake. Like, I think they're doing it as a pride thing. Like, I don't think they want to admit they're fucked up and they may have accidentally caught the wrong guy, allegedly. So I do feel like Luigi might have just been at the wrong place at the wrong time, and I don't want to put too much hope about that, because again, I don't want to give you guys false hope, but I'm also not just saying that because I'm a Luigi Mangione supporter, even if some mean people out there say I'm just a fangirl. I am not. I'm just giving you guys accurate information about Luigi Mangione's case. I have the right to do that. Even looking at all the actual documents and evidence we've been getting for over the last couple of months, I do kind of feel like Luigi might have been at the wrong place at the wrong time, sadly, and now look where he is now, and it's kind of sad, honestly. Poor Luigi. But I do kind of feel like it's a pride thing. We've been seeing it for months now, where how much the prosecutors have been like scrambling to find anything and breaking laws a lot to basically get anything against Luigi Mangione, and even the police have done that as well. It'll be very interesting to see what will happen near when we get closer to the actual trial date. And I do worry a little bit about, like what I mentioned earlier in the video, about the maybe second wave of suppressing Luigi Mangione's name, and I'm a little bit worried just because of the suppressing of information, accurate information on Luigi Mangione's case, and I don't think that many people will notice unless you're in the Reddit threads or you're weird like me who does these videos and looks at every single document that comes out with this case like a little weirdo. But I do worry about that because not many people are keeping an eye on this as much as some people are. I think that could also be bad because the public don't really care about this as much as they used to. So I am going to keep talking about Luigi Mangione's case, even if my channel isn't that big. I'm at least keeping all the accurate information with Luigi Mangione's case out there for some people. Even if this channel isn't that big, it's fine, whatever. I really want to keep the accurate information on Luigi Mangione's case that I don't see many people do with this case. Like, we've seen this multiple times, like even at the very beginning when this all started, where the prosecutors and police have lied, broken laws. They've done so many fucking things to basically have something against Luigi Mangione, and now they have Luigi Mangione's medical records that I'm pretty sure they might accidentally leak to the press. And again, there's a HIPAA violation, and I mentioned that in my last video, but like, we've seen it so many fucking times, and it'd be very interesting to see what the hell's gonna happen. Like, what's gonna happen? Like, I hope this is gonna go into Luigi Mangione's favor for the amount of times the police and prosecutors have fucked up in this entire thing. It'll be very interesting to see. I think that's really it for my final thoughts and all that. I probably had more, but like, I don't remember them. I'm so tired. I need so much more coffee right now to function. It's been a long week for me, honestly. But I will cover Luigi Mangione's next court appearance. That's going to happen next month So Luigi Mangione will appear next month in court on Tuesday, 9 a.m. on the 16th of September. So I will be covering that in my next video on Luigi Mangione. And I think that's really it. I'm going to move on to my throat hurts like hell. Oh my god, the sun is back. Thank you for watching this week's video. I hope you found it interesting. I will keep doing updates on Luigi Mangione's case. I feel like it's the right thing to do for Luigi, and keeping all the accurate information on him all in one place. So hope you guys liked this week's video. Hope you guys enjoyed it. If you have like any discussions or anything like that about what's going on with this case, please leave it in the comments down below. I'll be very curious to read what you guys think. Thank you for watching this week's video. I hope I upload every week, sometimes 3 times a month, depends what I'm working on. Some videos take longer than others. You can follow the channel's social medias. That's where I do little updates on the channel and what I'm working on, and also like when I get new documents or I come across new documents on Luigi Mangione's case, I pop them up on there so you guys can go see them when they come out instead of when I make these big long videos. Unless you guys like these videos, then thank you. Or if you guys want to follow me personally, all my social medias are down below as well if you want to follow me on there. And there's also a podcast of this. I should keep mentioning it, but like I forget every time. If you guys just want to listen along, I do have a podcast of these videos, so if you guys just want to listen along, you can go listen to that. But yeah, thank you for watching this week's video. Bye.